Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. And with me today is Mr. Uncivil Law.
What's up?
Hey, man. How's life treating you?
Well, YouTube hates me, but other than that, it's going fine.
Yeah, so you mentioned that. Should we talk about that for a minute? Well, let me say this. We're going to get into the shooting of Chad Reed. So I guess I'll do this a couple times. Trigger warning. You will see someone get triggered to the point of pulling a trigger, and you will see someone get shot if you watch the stream today, which you should do. You should not shy away from the realities of life. It is not an overly graphic video, but for some people, watching someone get plugged is not their favorite thing to do. So we will be doing that. We will be talking through kind of the situation. And then we will watch probably another person get shot as we preview the trial of Kim Potter and the shooting death of Daunte Wright in Brooklyn Park last year. So that is going to happen as we go through this thing. But for now, let's talk about what happened to you, good sir.
Yeah. So on my channel, I have an ongoing series. Haven't done an update in a while. I've got 50 plus of these videos that I call the Capitol Riot series, where I pick people who were involved in the January 6th event on the Capitol, and I read the official FBI probable cause documents for the arrest warrant, and when they exist, because sometimes they didn't, the DOJ official indictment from the grand jury. And so I review the facts as they're laid out by the FBI, who thoughtfully provides receipts, many receipts of photos and videos and the people confessing and so forth and so on. So it's like, well, this looks like a pretty good case, basically. In the 50 plus videos I've done, at least as to the surface level charges. I mean, obviously there are possible defenses that go beyond this, but just onto the surface level charges, only once have I said, I think the defense has just a good case. I don't think any of these charges really make sense from the facts. So that's one. And so that, basically they're all pretty well validated, at least to the surface level on probable cause. And so number 29 of these, which I did in February, YouTube decided to remove from my channel and give me a community strike, which is technically a warning at this point, but still.
You did this in February?
Yes.
It was 9 months ago.
Correct.
Are you aware of calendars? And that was 9 months ago. Why on earth are you being YouTube and removing this 9 months later? Like, why did you
matured? I don't know.
Why did you wait so long to get your warning strike?
Yeah. And then the grounds that they removed it on were very strange, because the sort of top line header, what you might consider the category of the rule, was harassment and bullying. But then the actual description didn't match that at all. It said that my video incited or promoted violence. So I'm like, well, that's not really bullying. So I'm not sure how these two things go together. And
did you promote or incite violence?
I did not. In fact, I pretty much mocked the shit out of the people for their stupidity, which is, once again, validated by the photos and videos and the Facebook posts and the phone calls and the radio interviews. And there's so many confessions with the FBI. Please come into my house. Let me tell you my story. It goes to one of my older jokes on this. The FBI is the only one who wants to see the slideshow of your visit to DC.
Yes.
You have the slideshow no one wants to see. The FBI wants to see the slideshow. They're all about the slideshow. They love to see it. And
they want to see your flight itinerary. They want to see the hotel bookings. They're tell me about.
They really want to know every part of your story in intimate detail. They are very interested in how you travel. How did your travel go? What did you fly? What flight number? How was it? Who were you with? And so forth and so on. They're very interested. So it's good for those people from those angles. But no, I don't think I was promoting or inciting violence much as making fun of the people who are just idiots who went to the Capitol and basically, stormed the Capitol and were just total absolute morons and broke several federal laws in doing so. So
yeah,
I'm reviewing official government documents. These are, The FBI says, well, here's an official government document, our probable cause for arrest. Like, looks pretty good. Here's the grand jury. Here's the charges we think. I'm like, looks pretty good. But apparently this is somehow promotion. I don't understand.
Yeah, it's a really weird thing because if glorifying promoting violence exists, right? If that is a thing that exists, then the people most guilty of it on a daily basis are news stations. If it exists in this way, we're reporting on facts and the realities of something that occurred. Well, sometimes news stations do that. They're supposed to. But if that amounts to glorifying or promoting violence, then there's basically nothing. I mean, nothing can be done about it. Like, you cannot talk about what's going on if that's the case. That sucks, man. And
I'm now gonna make fun of the chat because they apparently don't understand words. As I said, I think several times, these are initial level. Like, these are just initial level. I'm like, it looks pretty good. I said there could be other defenses. People are like, well, maybe they're related, maybe this, maybe that. I'm like, yes, I know that. All I said was, on the surface level, as an initial matter, on first impression, I used many versions of these words. Because I know, and you know, that there are defenses beyond that. I'm just like, well, what are we charging them with? Trespass, entering the building. What evidence do we have? Here's a picture of them entering the building. I'm like, well, that's pretty good evidence they entered the building for a probable cause. Are there defenses? Yeah, there might be. I'm not an idiot. Please pay attention to my words, chat. Do better.
Yeah. Be better. Be admonished. No, it's because that's how lawsuits work, whether they're criminal or civil. The initial allegations come in the form of a complaint, and that complaint lays out either a prima facie case or prima facie showing on the civil side, or on the criminal side, a probable cause statement. Does the government have enough evidence to suggest that this person can be brought to trial on these charges without considering any other defenses or anything else? And the answer is a lot of times, yes. It's a pretty low bar. They just have to do the work. In fact, almost any arrest can be justified if they do the work. And many of the cases which are thrown out for lack of sufficient probable cause aren't because there isn't a non-existence of probable cause for the arrest. It's because they failed to articulate the probable cause in the charging document. They left out something critical, like maybe they left out that they tested the drugs. Maybe they left out that the person made a threatening statement. They forgot to say that the person actually made the statement. I had a case thrown out for threats of violence because they forgot to include an actual copy of the threat of violence that was allegedly posted online. So when they made the complaint, they just said that the person made, a threat, but then they didn't
say what the threat was.
They didn't say what the threat was.
Which makes it difficult to find probable cause. There was a
Right.
threat. It's kind of a legal conclusion. What's your underlying evidence? Crickets.
Yeah, and they could just post a screenshot
Yeah.
of the thing because it was online. The judge's like, where's the statement? So the probable cause statements typically are very easy standards to meet, and they're obviously weighed in favor of the state. They're putting forth their best case, which is why the Kyle Rittenhouse the probable cause statement and complaint was so baffling, because it didn't.
Yeah, their initial complaint, as you said, read like a defense lawyer. I don't remember if I made a video at the time or not, but it was baffling to me too, because a lot of those statements, like, wait a second, this seems to be the defense's case. I don't get it. The whole thing was weird.
Yeah, and so that's the initial matter. But getting back to the subject at hand, you're reporting factually on a major event that happened, and you're saying, okay, here are the government charges against people, plus the evidence of what they did. If that is somehow endorsing violence or promoting violence, you're saying literally, here is what was happening, and now they are federally charged with criminal actions and will have to go to trial for it. That seems to be dissuading the activity, in my opinion.
Yeah. I mean, I would think so. I would think exactly that. I'm making very public, here are some of the possible consequences you people at large may face in the future if you do things like this, which, You probably shouldn't need to know. It's probably illegal. That should just be kind of a thing that you kind of would know. But, to the extent you don't, here's some potential. Here's some prizes you can win. One of the very first video I think I did in the sequence was my game show, and where I just went through a whole list of, I just pulled basically every statute I thought that could apply. And I'm like, I'm Monty Hall. Here are some of the many prizes you can win. And the best thing about this game show is that, at least theoretically, all of you can win all the prizes. It's the greatest game show ever.
Yeah, they don't run out of prison sentences to give.
Yeah.
It's amazing how that works when you're the federal government. Okay, well, man, that sucks. I hope you can get it removed, because
We're still fighting on the back end. I filed an appeal, which was decided in like 20 minutes or something. So that was really super encouraging. YouTube gave it a lot of thought. My working premise on what happened is that one of the people involved, one of the suspects involved, whose name was obviously in the title, or their lawyers, filed a complaint to YouTube because they're sad about the fact that they're suspected criminals. And that's my working theory of what happened. So maybe.
Well, good luck with it, because for those who don't know, he has gotten a warning strike. You get one warning strike ever on your channel. They never go away. They're like, well, this is your one warning. It doesn't matter if you're a good boy for the next 5 years. They do not take them away. They're permanent. And once you have a warning strike, any subsequent bad boy strike you get is a suspension, and you are prevented from uploading, streaming, commenting, making community posts for 7 days. And then those stay around for 90 days, and they fall off on a cycle. And if you get 3 of those within the same period, then your channel is deleted forever. So
yeah. And so since I have 50 plus of these, my concern level has increased.
Yeah. I would try and I would fight it as hard as you can. I mean, I fought mine for weeks, my warning strike, and they kept it on there because YouTube is asshole. And so they did that. But yours sounds I don't even want to say less justified. Mine was so ridiculous.
I'm going to post it up on locals so people can see it. So
yes, absolutely. What's your locals?
It's uncivillaw.locals.com.
Ooh.
Yes.
So you can go there to see the spicy video that was deleted by YouTube.
Too hot for YouTube.
Too hot. But yeah, man, let me know if there's anything I can do to help. Community guidelines are the worst team on YouTube. They issue those summary denials of appeals, and there's nothing you can do or add to them. It's so annoying, but and unjust, frankly. It is, I would dare say, uncivil.
Yeah.
All right. Well,
we can move on to other topics, such as my apparent new appreciation for legal eagle. We can move on to that.
I don't know if I want to talk about that.
Okay, we can move on to other things.
Well, I've got some super chats to read that came in before the show and some that came in during the show, and I want to read those. And then I do want to talk about Chad Reed. I want to get into the shooting in Lubbock, Texas. I also need to make a show announcement. Monday, this time, Monday, the interview with Photo Chad, Nathan DeBruin, right here, 1 p.m. So if you are someone who is following along the Rittenhouse case, Nathan DeBruin became a bit of an instant hit with the chat. They liked him very much. He is the guy who basically put Krause under cross-examination from the witness stand, which was colossally funny. And so he will be here on Monday at 1 p.m. Central Time. So make sure you guys tune in for that. I will be talking about it. Soon. Mike M says, why don't you get Kyle or Richards? Well, it's if I could just snap my fingers and have people appear on interviews, this would be a very interesting channel. I would have Joseph Robinette Biden Jr. sitting here doing this pose for one of the shows in a heartbeat, because I think that would be funny. But it's a process getting people on for interviews, and Mr. DeBruin has graciously accepted the invitation, and so yes, he will be here. And hopefully not the last interview from the Rittenhouse trial. I have many people I would like to speak to. Navy Ret 09 says, I think a group of lawyers would be called a suit, and your day show would be called the lawsuit. Ooh. I do need to come up with a new name. Just because
Invoice isn't working for me. I have to be honest. It is. If I get a blackball veto on this one, it's not working for me.
Well, I was meaning rather than law-splaining the interwebs, because I made that title 4 years ago as like the cringiest boomerist title I could think of. Mainly because I kept seeing people like Popat out there, quote unquote, writing up law-splainers, and I was like, that is the dumbest thing I've ever heard of. And hence the joke with the interwebs, because it sounds like something an old moron would write. That's why the title exists. And I realized this when I went on a radio show the other day and was listening as they announced my appearance. He does law-splaining on his channel with law-splaining the interwebs. And I was like, oh God, we need a new name for this. We need a new name for this.
I like law-splaining. I think it's good.
Well, you have just come out as a boomer, so thank you.
Okay.
For that.
I'm supporting you because you created it, right?
I do. Oh, look, you are, and you're being very friendly in that. But I don't know. LawTubers United is nope. That sounds even worse. Flock of Legals. That's kind of funny. Flock of Legals. Okay, call me Straws said the unicorn sticker. Clay Neal says Google John Horn, Pasadena, Texas, 2007. Stand your ground is very strong in Texas. The Lubbock shooting still hasn't gone to grand jury. My understanding, though, I believe that keep seeing something out of the corner of my eye. I believe the guy has now been arrested, the shooter. So we'll have to take a look. I've got a mugshot. I don't know if it's from the current action or if it's from a prior action. Sublime and Slime says, thanks for discussing this topic today. Interesting to see how people will bring in the castle doctrine and how it applies. Obligatory grift for the Save America Discord server, and patiently awaiting an AMA with you and maybe the panel. And he also says, sorry for your problems with the fascist YouTube brown shirts on civil law. So
I think they're more red shirt commies, but either way, it's hard to tell the difference sometimes.
The denialist says, how much would it take for you to step back and let Uncivil say controversial stuff that would rile up the chat and their feels?
Apparently most of the stuff I say is controversial to the chat.
Do I have to step back for him to do that? I mean, kind of just there. Oh, and we are going to add to the panel. We have another guest. Welcome, Legal Bites.
Legal Bites.
Oh. Hi, how are you guys? It's been so long since I saw you guys.
Good. How are you?
I am doing very well. It's officially the start of the holiday season, and I'm very excited about it. I am here.
Well, at least you wait till after Thanksgiving for the shirt. So yeah.
Well, so we actually we have been cheating a little bit. We have some lights that have been up inside our home. But only on the inside.
Now, what kind of lights? Are we going the all white? Or are we going the multicolored lights?
A little bit of
are you a white
a little bit of column B.
You're a white light supremacist, though.
No.
Are they the old school big bulbs?
They are. Cool. They are whatever we can find in our overseas lifestyle.
You said, though, little bit of column A, little bit of column B, which means that you do have some strands of just white lights, right?
Yeah. Yeah.
Now, on a per light basis, would you say there are more white lights than other lights?
You mean overall, looking at the overall lights in my space? I guess more than any other single color, there are more white lights, but more.
Oh, now we see.
But that's because the colored lights are a mix of colors.
Oh, the colored lights now. Oh my God, I cannot believe
what
I'm hearing.
Color.
Do you guys? seriously,
We're not talking about people here, okay?
Can you bring your terminology into 2021? I mean, this is just grotesquely offensive.
Colors of your lights of color, lights of diversity. Is that what we're going to call it now?
I don't know. What would you call it? What would you
well,
call
I don't
it?
know. You know what I would call it? I would call it a heck of a lot of Christmas cheer to make up for the fact that last year we moved in the middle of November and we didn't have any of our stuff for Christmas. So we are unabashedly all in for Christmas to make up for the sadness that was being in quarantine on Thanksgiving last year, and then not having any of our stuff and sort of trying to cobble together some semblance of a Christmas.
Well, thank you for being the first person I've ever heard pronounce lights with 2 G's and a hard R at the end. Very, very disappointing.
That is not what happened.
Welcome to the show, Joe.
Thank you. Thank you. Thank you very much. I'm going to take off my Binger scarf now. And it's cold here.
Scarf.
I knew you'd appreciate it.
Yes.
So I just came in from a cigarette. So, yeah. So first of all, condolences to you on getting your strike. Although you probably enjoyed the email because they said, good news. Good news. The way they word that warning strike, or so I've heard, is that they say good news. This doesn't affect your channel at all, except for the fact that if you say something that seems totally innocuous about a disease, in that case, we're just going to ban you for a week, and if that happens again, we'll ban you.
Yeah, this
for
doesn't
2
come
weeks.
with any penalties, but the next ones do.
Yeah,
except for not having your channel for a week.
And good news. If it happens a third time, then goodbye. You'll never talk to us again. So it's very upsetting. I'm sorry for you about that. I really am very sorry. I should mention to you guys from the get-go, I do know a lot about this Lubbock City, this Chad killing, and I only have 1 hour, and then I gotta close down for Shabbos and stuff like that. So if we could try to weave our way there, because I
feel like I'm primed from our last conversation on Eric.
Yes. Is that what you showed? Is that what you showed that got you in trouble? The shooting? Is that what you showed?
I got in trouble for something I did in February regarding discussing charges from the Capitol riot, January 6th stuff.
Sorry, that's terrible.
I mean, which is funny.
I'm laughing at YouTube,
the part that's I mean, maybe not funny, but that's ironic is that your whole point in showing these cases is you're not friendly to these people necessarily.
No,
really, at all.
No,
so you're not glorifying what they're doing.
I got notable resistance from my own channel when I was doing it, but I was like, well, I think this is bad, and I'm going to say it's bad. So yeah.
But I'm saying they hit you with a warning now for what you did in February. It's pathetic. I actually just came off my first strike, though I passed my 3-month period, so I feel unfettered now that I can basically get another strike. Because if you get 2 strikes, then you really have to walk on such eggshells. I don't even know if I would come on YouTube.
Man, I feel like I'm on eggshells now, to be honest. I mean, it's step 1 of 4, and I don't like being at step 1 of 4.
Especially when we don't know what that step is. You never know what that step is when all of a sudden, boom, they think you did something wrong, right?
And the other my biggest problem is the inaccessibility of the community guidelines team. I mean, you cannot in any way get a hold of them and say, no, wait a minute, this isn't glorifying violence. I want to say my piece. This isn't this thing. You get your little appeal with 300 characters, or maybe you get 800 if you do it if you do it on your phone or something. And that's all you get ever to say. Even a snob like me who has a YouTube partner manager, an employee at YouTube, I can't get to the community guidelines team even through my partner manager. They don't talk to them either. And when they do, and your partner manager says something uncomfortable, I don't actually see where he violated the election policy or where he even talked about fraud. So can you show me where that happened? Then they just stop talking to your partner manager, and there's nothing that anybody can do about it. It's amazing.
I want to warn you while you have this thing up here. I personally would never show this on my channel because I think you're begging for a strike.
No, this won't be a strike.
This is glorifying violence. They can call us glorifying violence.
We are definitely not supporting whatever this is.
We are doing this for purposes of education and
100%.
to analyze it from a
And
legal
maybe do a
perspective.
legal analysis about what crimes, if any, might this implicate.
That is what we're doing.
Yeah.
This is no one should think that this is a glorification of violence.
And I will say I just watched the video in between Eric Hunley's channel and joining on here. That was one of the reasons why I why I was a little bit later. So
Yeah, this
that and I was making more merch. You guys interested in all my quote merch?
Nice.
Oh God. This the other thing
that for you.
what this will probably do is restrict this video to 18 plus. That's the most likely outcome, is that this will be an 18 plus video. By the way, big shout out to the Odyssey crew watching over on Odyssey. You can also watch this on Odyssey, which will not label this video 18 plus or ever give you a warning strike for merely talking about factual information. So you can always watch over there on Odyssey, and a big shout out to them for helping out with alt tech. Let's see. Brandon Lesko says, I will unabashedly send my first super chat to request you break out the whiskey. Oh boy. Maybe in a minute. The Engaged Few says, if you don't like Invoice of Lawyers anymore, I like Invoice of Lawyers. Kurt's the hater.
I'm not a huge fan of Invoice.
Oh, listen to all these people shying away from the reality of money grubbing, soul sucking lawyerdom. Okay. Okay.
No. We're not opposed to that. I'm not opposed to that, right? You guys aren't.
How about a
Good logic? You're the one that is like teaching us all how to grift on getting subscribers.
You guys are shameless. You're shameless. It's disgusting.
Here we
I feel
go.
dirty sitting here with you guys.
The Engaged Few says, how about a new name that everyone can support? How about a jail of lawyers or a gallows of lawyers?
Gallows is not bad.
There's not a big enough gallows in the world yet. Okay. I will have one drink of Middleton whiskey here. Okay. But yes, this is not going to be glorified, but we're going to just talk about the legal realities here. And if we're going to glorify it, we'll do it in our own private thoughts. Here we go. Which I don't know why anybody would particularly glorify.
There will be none of that coming from me, just to be clear.
Well, here, chat, I'll communicate any glorification this way. There you go. It's been given to you. So because that's what YouTube's going to do anyway, is try and read my mind. Here we go. Here's the video. Again, you're about to watch someone get shot. It might bother you. Don't be bothered by it, but it might.
From you.
This is on video. Get off of the property.
Where's my son?
Her ex-husband has showed up.
That's
they
terrible
even
quality.
blurred it.
Yeah,
That's
there's another
anything.
vantage point that you can see it from.
Yes, we're gonna watch both of them.
That's much clearer. Yeah.
Okay,
We're gonna
so
watch both of them. This is
Okay.
the initial video.
Yeah.
Whoops.
Oh my! What the hell was that?
Oh, I like this one.
Oh my god! Wow!
Yes. No, I wanted to show the initial video that came out before we do the later ones. So I'm going to those. The new video was released just later yesterday by the wife of the deceased. But notable points of that. Are you going to load up here? What's going on?
The
here?
one you have should be. Is it 2 minutes and 16 seconds?
Yeah.
All right, that's the right one.
Yeah, I'm just waiting for it
If
to
it's
actually
blurry,
load.
I have an unblurry one.
More information, please.
But some notable things that happened in that initial very fast video that was shown is he does, the deceased does say, I'm going to take that gun from you. He says something to that effect. And then there is a slight physical altercation in which they do a merry-go-round do-si-do, and the guy with the gun is is pushed out of the way, and then that's when the shots are fired.
I would like you, when you're watching this video, because I actually noticed the more often I watch it, the worse it looks for the defendant. Just notice the position that green shirt, the guy who gets killed, Chad Reed. Notice the position he's in the second to 2 seconds right before he gets killed, after he flings the guy away. Because to me, it looks like he's completely standing still. But you guys can judge for yourselves.
All right, here we go.
This is not the. Can I give you a better one to watch?
Yeah, you got a better quality one?
Yeah, I have better quality. Well, okay. So the one I'm about to, I'll give you in the description. I'll give you right here is a Twitter link that I share in private chat. It's 2 minutes and 16 seconds because it has 2 different video camera footages. The first one is what we just saw, but unblurred, and then it has this afterwards. And you get 2 different. From this one, you can't watch the victim at the moment of shooting. You won't. He'll be off camera from this second angle. The one I just gave you now starts with what we just saw, unblurred, and you can see green shirt and how he's not moving at the moment in the second or 2 before he gets shot.
Here, Joe is poisoning the well by interjecting his personal opinions about what happened prior to us watching the video. Oh my God!
Are you testifying? Are you testifying for the witness?
I haven't begun poisoning. There's a lot more. I think this is awful.
All right, here we go.
From you and fucking.
This is on video. Get off of the property.
Where's my son?
Her ex-husband has showed up.
That's the first one. Now's the second one.
All right. So again, very uncomfortable sometimes to see someone shot. It's not like the movies. They don't fly backwards. There's none of that. They just drop limply to the ground very often. So here we go. Oh, fucking hell. The Dixie Chicks.
It's Texas.
Yeah, it's Texas. You can't play the Dixie Chicks. Also, this is definitely going to get a copyright claim. So, but that's fine. Let me just break this up. I can do this. Look, I can make this fair use. This song, Wide Open Spaces, sucks. The vocals are weak. The Dixie Chicks are garbage. And I'm sure based on the low quality of the Dixie Chicks' musical production that they actually endorse the violence that we're about to see. I could just tell because they did violence to the song itself and to the poor sap who wrote the lyrics and the producer who put it together.
Nice.
And they should all be in jail. Okay.
With Kyle Carruth.
Now I've criticized. Is that Kurt as resident intellectual property guy?
I mean,
is that sufficient criticism of the work?
Let's use it in the is there any sort of an indication that we can use from a legal perspective on what this can tell us about the people involved? I don't know. I'm BSing.
I'm just providing. I have to provide fair use criticism of the work itself. And I really think that the shrill vocalist of the lead of the Dixie Chicks, whichever one that is, the short-haired one, or the dark-haired one, or the chunky one, I can't remember. I don't know. I don't know any of these individuals.
I don't think the Dixie Chicks want this song. I don't think they want this song associated with this video. That's my gut. My gut says.
I said, they did violence to their audience. I think it's only fitting that it be accompanying a violent encounter. So here we go. Back to this though.
I've already got the pump on the way to your mom's house. Because that's probably where he is. It's not when I'm done working.
Is that the guy's ex?
Yeah, I think so.
Right there. Okay.
The mother of his son.
I don't care if you wanted to see him or not. I get him at 3:15.
I got him at 3:15. He said.
Okay.
You keep trying to keep my son from me. I'm fixing to drag you and Anne Marie and everybody else into court. I'm subpoenaing your mom. I'm subpoenaing Anne Marie. On video. I'm very please do it. Right, you better fucking use it, motherfucker.
He comes back out with a gun. He didn't have a gun at the beginning. He went inside and got it.
Now here's the question though. is Mr. Reed engaged in a provocative act here? Because
Look where his hands are. Look where his hands are.
Merely getting a gun in Texas on your property is not provocation.
That's probably true.
Look where his hands are. Look where.
But look where
Chad,
his body went. His body went straight to the guy. Straight. He didn't back up. He didn't in any way raise his hands or offer a non-aggressive stance. He went right up to nipple rubbing. And if just before the chat gets any weird things about that, that's where two men typically will puff out their chest and rub their chests against each other while yelling. It's
a very weird way to label it, though.
But that's what it is. It's this weird, it's this primitive, very
You're the only
primal
human who
act.
ever said that. You are the
No.
only person. Only on Ricardo Law will you get that type of
Look.
terminology.
That's the truth. That's what it is. But yeah. So
I'm going
he
to Google
goes-
nipple rubbing and see if it's ever been used. In a
yeah, please Google
Yeah,
nipple
go-
rubbing.
physical
I'll
fight
stream live.
type of context.
Share your
I'll share my
your
results
search
with you.
history with the chat. Okay. Sorry. One thing that people should know about me, if you haven't figured this out yet, I process things through levity and comedy, including like stress and disturbing and distressing things. That's how I get through things. So if you hear me making jokes about stuff during this, I actually don't like watching people die. I'm not a big fan of it. I'm not a big fan of shooting death. But I process through things with jokes and levity. So I'm not trying to be insensitive. It's just how I work. And you can't tell me how to do anything differently, you bigots. All right, here we go.
Can you go back maybe 3 seconds or something?
Absolutely.
So we can see when he first comes out with the gun.
Yep.
All right.
I'm going to go back to right. Oh, he's got the gun already there.
Yeah.
So right
Yeah,
here.
go
So
back.
I'm
Yep.
going to subpoena everybody on earth.
And everybody else in the court. I'm subpoenaing your mom. I'm subpoenaing Anne Marie. On video. Yeah, I am. Do it. Right, you better fucking use it, motherfucker. Because goddamn it, I'll take it from you. And fucking
Call the police. Call 911. Call
Yeah,
911.
he put his
Call
arm up
911.
there.
Call 911.
Warning shot.
Look how far away he was.
Call 911.
And the guy's standing still.
Wait, I can't keep it
I
on the
have
dead body.
video, Kyle. You did it, not him.
I told all of y'all to leave.
We came to get his son.
He's not here.
She should have told that. She should have told that.
They're continuing the argument.
Yeah, then I'm checking the body. Then I'm checking on him.
I
Is he
asked
okay?
you to leave. I did everything. I did not want to do any of this.
This is the guy's wife, right?
I-
The dead
think
guy's
it's
His
wife,
current
girlfriend.
wife or girlfriend or someone. I think it is wife, because I think she mentions like later in the audio there's something about like my husband or something. I think.
All right. So I have to be careful how many times we play it, because that can look like glorifying and all of that stuff.
Yeah.
And again, we're not glorifying or
Probably is
endorsing the
enough
behavior.
for us to talk through. If
Yeah.
unless we have more specific questions, and maybe we can go to a specific part or something. I don't think we need to replay the entire thing again.
We could go through the criminal code and try to see if it squeezes in anywhere, but
So I shared with you in the private chat the relevant section of the.
Yeah.
I'm gonna
So
bring
one
that up.
one thing that I noticed, so this time as opposed to last time watching it on my own, it looks like they're on the front porch, right? They're not like within his greater property, right? Like he's technically on his property, but it's like we could call that the curtilage, right? I know we were talking about that before, and I think during one of the Vercata streams, the curtilage, that's like the area kind of immediately outside your home, like right outside like your front door or your back door. So that can be significant for, I mean, that's come up in ways for like due process, Fourth Amendment issues with the police.
Andrew Branca mentioned that when we were talking about curtilage the other day, is that it's the part of your property typically adjacent to the house that is in quote unquote everyday use. That would be a part of everyday use of the house. So you actually get, or everyday use of the property. So one of the arguments that could be made that he mentioned, and this is all credit to him, that for example, if you have a shed with a snowblower in the winter, that could potentially become part of the curtilage or usable area of the property. Whereas in the summer, if it's just a storage shed that is not something that you would be going to with frequency, that changes the calculus. But I think here we can say that a porch or a patio are likely part of curtilage, and curtilage matters in some places. In Texas, I'm not so sure it does, because in Texas you have a greater than just about anywhere else in the country ability to defend property using deadly force. It is not an how do I say this? It's not an objective automatic defense using deadly force, but in like Wisconsin or Minnesota, for example, you cannot use deadly force to protect property under any circumstances. In Texas, there are circumstances which you can.
Yes.
All right. Oh, wait, go ahead. What's up, Joe?
No, I don't think whether or not this is curtilage is going to be relevant under the Texas statute. Just as the way, based on my reading, because Texas statute starts talking about breaking and entering, and there's clearly no breaking, even if there is an entering. Breaking, by the way, for your audience to understand, when you ever hear the term breaking and entering, any minor act, it doesn't mean breaking a window or picking a lock. If you turn a doorknob, that's considered breaking, as for the purposes of defining breaking and entering. But clearly, Chad Reed here, the victim, didn't do any breaking of any kind. He might have entered. There might be criminal trespass when they ask him to leave. But I actually was looking up whether or not this could qualify as burglary under Texas law. That's one of the things I looked at, which is under Section 30 of Texas Penal Code. And it's pretty evident that any reading of the statute, I haven't looked up the case law, any reading of the statute, it's almost impossible to understand how this could be qualified as anything other than potentially criminal trespass. So when we're looking at the statute for justification of self-defense, that should be relevant, that if any of you think maybe this is burglary because he was asked to leave, it seems difficult to understand how Texas law would make that application. So, and that's why I'm saying curtilage isn't going to matter, because he's not inside the house. He took no steps to go into the house. So that's going to become relevant as we're looking through the self-defense statute.
Now, Leon's Law, my man Leon's Law in the chat, a freshly minted lawyer right off the bar presses.
So those bar elements are still in his brain.
Yeah, he says curtilage is. He correctly states that curtilage is search and seizure law, and that is true.
Yeah, that's true.
However, curtilage has applications within castle doctrines in various states, and so that is why we're bringing it up, and because the presence on the curtilage. Plus, if you're looking at this strategically from a criminal defense perspective, you go, okay, what arguments am I going to make from the jury? And the proximity to the house itself is going to, while it may not be legally relevant in the strict application of the law, it's going to be strategically relevant in the fact that, this guy was coming into our home. He's approaching our home. He's getting closer and closer to our domain. In fact, at the time the altercation starts, I'm on my porch telling him to leave, and he enters onto the porch, which is potentially relevant there. The guy is in the yard and he enters onto the porch. If I'm defending the shooter, then that's part of the argument I'm making. And so that's why, curtilage, while it may not be strictly in the legal sense, it's that sort of conceptual argument is going to play into the self-defense claim. I just want to point out, because I know you only looked at it once or twice. I've looked at this video like a dozen times. And one of the things you mentioned, something I was looking for. The moment he walks out with the gun, Chad is not on the porch. He's clearly on his property, his private property area, but not technically on the porch. It's only when he comes out with the gun that he starts doing what Nick Recato would call a nipple rub with him, and he steps onto the porch to do that nipple rub. So, but I think all of that probably would be considered curtilage anyway, even not being on the porch, because that's an area that presumably Kyle Carruthers regularly uses in coming in and out of his house. So, just thought I would throw that out at you. Yeah, and we'll get to talking about it in some detail here. I'm going to share the statute because I do not think this is a clear-cut case. There are lots of people in the chat and leading up to this who said this is murder, and I saw about the same amount of people saying this is self-defense or defense of property in Texas, and it's justified. So I think there's plenty of room for people to look at this one and go, this is a hard This is a hard case. And I think it's a hard case too.
Self-defense is 9.31, by the way, if you're looking for that.
Okay. So we've got, justification as a defense. 9.31 self-defense.
No, that's not
God,
lethal.
this font is awful.
Yeah, the font is terrible. Lethal force of self-defense is 9.32. But this is just,
okay.
But you need to understand, to understand 9.31 because that's an element to 9.32.
But let's briefly talk about just initial observations of the video. I do want to get into that, but so let's try and put together a timeline without the video as a guide. All right, because get some of that. Remember that jurors either may not want to watch the video over and over, or as they're talking through this, may not have the video available for some of their discussion. I'm not quite sure. So let's talk about the timeline. So what we have is this guy comes to the house allegedly to pick up his son. There's a custody agreement, and he gets 3:15 p.m. He gets the custody switches to the dad. And if anybody's curious about that, parenting time always has to be exercised by the parent getting the parenting time. You have to go to get your kid. And that is, I believe, true in every state. You have to do it. If you don't show up to get your kid, too bad, you forfeit your time. Well, until you do show up. But you don't get to make that up. So he is properly going, I think we can assume, to the property to retrieve the child. But for whatever reason, the child is not present, according to the shooter and the ex-wife. Is that fair? Is that a fair assessment? Okay. So while there, he says, you're interfering with my parenting time. I'm going to take you to court. And the unfortunate or maybe fortunate thing about parenting time, specifically to try and evade things like this, is that you have to resolve parenting time issues through the court. You're not going to be able to force them. You have to bring a case to the court that says they're interfering with my time and you need a court order. A lot of other people said call the police. He should have just called the police to get his kid back. Oftentimes, the police will not interfere absent a specific court order about a specific time or incident. They will say this is a civil domestic issue and you need to take it up with your court, because they're not going to try and get into the interpretation of what a parenting time agreement says. So these things are supposed to be handled in court if the other parent is being unfair, which if you're a parent, though, and you're trying to exercise your parenting time, that's garbage. Right? Like, you're supposed to have your kid and they could just say, nah, you can't have them. And you have to then go pay a lawyer a whole bunch of money to bring a motion to enforce the parenting time. So that sucks. All right. So he's there, though. Kid apparently is not there, or they're concealing the child from him. One of those two things is true. And then the shooter goes and retrieves the gun from inside the house. At this time, I don't think anybody has made any particular threatening action.
Maybe getting the gun is provocation.
Well, yeah, but we were saying up to that point, I think was
before that point. Yeah, I mean, he wasn't making any sort of threats. The man in the green shirt wasn't making any sort of threats to anyone's life. He was making threats to bring everyone into court. And I would also say that his indication that he believed that his son was at his ex-in-law's house. He was indicating, the cops are about to show up at your mom's house. And she was like, well, why are they going there? He's like, because I'm sure that's where he is. That to me would indicate if I were to be on the prosecution side, I would say that indicates that he has no intention of going inside the home, right? Because if he believed that his son was inside the home, then maybe there would be a chance that he wants to storm in there and take him himself. But if he doesn't even think that his son is in there, then why would he go inside the home during this confrontation?
And just to crowdsource this thing at first glance, and if we get to follow this more, there's a poll that I just put up, self-defense or murder, simple answers, self-defense or murder on this. I should have put justified or unjustified. That's what I should have said. Sorry, but take it that way. Okay, so he does go retrieve a gun. Joe, your statement is that this is a potentially provocative act that would then are you asserting that, or are you saying that as like a as just dropping it out there like a fishing line.
I mean, I think that arguably, I'm not asserting that. I'm saying arguably,
Sure.
the state can make that claim that's a provocative act, and you actually see how it ends up provoking Chad Reed, where he starts doing the nipple rub as soon as he sees that. Beforehand, they had been face to face. They sort of backed away from each other. Then he goes and gets the gun. He's barking about, going to lawyers. There's no threat of violence. There's no talk of violence. It's purely that he's going to engage the courts to seek, the enforcement of his rights. And I think that no one was talking about there being any sort of physical altercation, except for until Kyle basically brings that gun out and says, "You need to leave now," or something to that effect.
Yeah. Kyle Kareth is the name of the guy, right? I want to,
Yes.
I'm not
Gareth or
avoiding it.
Caruth, yeah.
Yeah. I'm not avoiding saying his name. Like I
Don't remember.
didn't think about it until now.
Yeah.
Now that you mentioned it, and it's like,
And-
oh yeah, his name's Kyle.
And I
Kareth.
will say, if we want to go into provocation, I came. It's not like right out of like Westlaw or anything, but I came across an article from the Texas District and County Attorneys Association talking about provocation in Texas. Apparently, they call it provoking the difficulty. There are 3 elements that are required for it. Do you guys want to go over it now or later
Please.
or what? Yeah. Okay. So
Yeah.
so it's they said here, and so I'm citing the article because I'm not sure if this is true, if this is correct, accurate, or whatever, but I'm going off of this. They say that the state is not entitled to a jury charge on provocation, precluding the assertion of self-defense unless, so in other words, they're only allowed to claim provocation if there's sufficient evidence that 1, the defendant did some act or used some words that provoked the attack on him. 2, such act or words were reasonably calculated to provoke the attack. And 3, the act was done or words were used for the purpose of and with the intent that the defendant would have a pretext for inflicting harm upon the other.
Whew, that's a strong jury
No.
instruction.
Yeah, I don't think you're going to get to 3. That doesn't sound 3.
I
don't think you got
Two's
that.
hard. 2's hard. 3 is really difficult.
I actually think 3 in this particular instance, when I was watching it, after I watched it the second time, the way he steps back and takes that shot when he's already been flung away and Chad's standing there, it smelled to me, and there's no way I could prove this. There's really no way I could prove this. I don't know if I could prove this certainly beyond a reasonable doubt. It just smelled to me like Kyle had been waiting for this moment. He's like, I have my justification now to shoot him. That actually 3 to me is actually easier than 2.
Yeah.
No, there's
I'm
no way.
I'm just telling you how it
prove
looks. I'm just telling you how it looks to me. As soon as he's
Okay.
flung away, he sort of takes a moment, sets himself, and the guy's literally standing there like he could have been smoking his last cigarette and he's been sentenced to die. And he literally sets himself, ready, aim, fire, boom. I mean,
And
it happens in a second, not
Yeah.
in like 3 seconds, but still, it's not like it's a millisecond. He really
I would
sets
say
himself.
say if these 2 people didn't know each other, I would disagree. But because of the fact that they obviously know each other very well, they know how to push each other's buttons by now. I mean, especially in these kinds of cases, I would at the very least be open to the possibility that he knew that this was the kind of guy that would try to reach for it or grab it, or he would do the nipple brush or whatever it's called, whatever Nick likes to call it.
Nipple rubbing.
It's possible.
Come on.
It's certainly possible with other facts. Like we might
Yeah.
have prior instances.
Yeah,
and
there's
other witnesses.
so I'm saying
So,
that
yeah.
I'm not necessarily concluding that absolutely is the case here, but I'm very much open to that possibility based on the facts that we do have and other facts that we don't know but could be.
when I'm still looking for the provocative act. I'm looking for the provocative act that is reasonably calculated to as a pretext to
It
utilize.
sounds like it
Firing
can
at
be
his feet?
anything. It
Firing
sounds
at
like
his
it can
feet?
be anything as long as that's your purpose in mind.
Firing
but-
at his feet.
I'm trying to figure out what that would be. Is firing at
Going-
at someone's feet calculated to cause them to attack you to then use self-defense against them?
Or even coming out with a gun, maybe.
Yeah,
mean,
I
look,
would say
he fires
going
at his
inside,
feet.
coming back with the gun.
That doesn't seem reasonable to force someone to attack me. Like
He
if I go get
fires
a gun,
feet.
I'm not thinking if I go get my gun, this guy's going to rush me and then I can shoot him. Right?
Okay,
Like
let me think about this though for a second.
that seems unreasonable.
Okay. That's why I agree with you that I don't think getting the gun is this. I think when you fire at the ground there, what the hell is this guy going to do? He's either going to turn tail and run, or he's going to, or I mean, or he's going to fight with you. I mean, it's very likely he's going to try to grab that gun, which is what he does. And the moment that he grabs that gun, seriously, and flings him away, and then he's just standing still. From the moment he grabs that gun, there was nothing Chad could have done to stop Kyle from shooting him, unless he ended up with that gun, because he literally flings him away and then just stands. He's literally standing there with his hands down.
You muted yourself. I didn't mute you. You muted yourself. Did you pull your
That's
headphones
you, Grandpa
out?
Joe.
I think he pulled his headphone plug out and it.
Oh, could be.
And there's also, of course, reckless endangerment, or as Texas calls it, deadly conduct, by
Yeah.
knowingly discharging a firearm in the direction of an individual. Then that's a class 3 felony too.
Right.
Yeah, you should never, like, to be clear, you should never ever fire a warning shot. But
There's
I
no
don't
such
know
thing as
that
a warning shot.
Yeah, there's no such thing as a warning
Basically.
shot. And to say that warning shot, however we're calling it, that there's sufficient provocation for that, I don't know, because any provocation, unless we can find something more specific in the statute, would be non-deadly force, and he's responding with deadly force. So I think the deadly conduct, felony 3rd degree, looks pretty promising for the state.
that's certainly a possibility. So that's and then does that amount to provocation? Does that again, like, to me, okay, even saying that that's a felony, I get it. But I'm not sure that a warning shot can be reasonably calculated to assert that someone would then attack you so that you could justify self-defense. Because, I mean, the warning shots being illegal aside, the idea behind shooting a warning shot is typically back off, not run at me, bro. Right? Like,
Yeah.
because if you want to use a pretext of provocation, like, you would just find some other way to pull the trigger at the person rather than shoot a warning shot and then hope they respond by coming forward instead of going back. So I'm not sure I'm sold on the provocation.
The warning shot you're describing, which will get the guy to back away, is if the guy is 10 feet away from you and you shoot at his feet. Then the guy's not going to charge you. But when he's standing nipple to nipple with you and you fire that warning shot at his feet, I think it's far more likely to induce the reaction that ended up coming, because the guy knows the gun is right there. It's in arm's reach. So you fire a warning shot at me. So for him grabbing the gun, it wasn't surprising to me that he grabbed the gun.
Well, I mean, it's not surprising to me that he grabs the gun after he enters onto the porch when the guy has the gun. I mean, that none of the physical altercation didn't surprise me at all. But remember, that is the underlying thing. So all the more so. If you're saying it's not surprising to grab the gun once he came on the porch, all the more so once the guy fires a warning shot at his feet, that all the more likelihood that the guy is going to try to grab the gun. But that's not like, okay, the fact that he enters onto the porch and then an altercation ensues where he grabs the gun, that's still Teal Guy. That's on Teal Guy walking onto the porch. Because to me, again, and you're talking about firing a warning shot from 2 feet away is bad, right? Because then the person is in the space. But remember, he wasn't 2 feet away. The guy comes out with a gun pointed down and he enters his space. He goes straight to the nipples on this guy right away before anything happens. So again, I'm not so again, I think this is a tough case, and I'm making the argument right now for the shooter, not because I think that the shooter is justified, but because it's a really complex situation. And one thing I do want to do, someone said that the Kyle Kareth asked Teal Guy, Chad Reed, to leave the property prior to getting the gun. So I've backed the video up to the beginning, and I think we can watch it without getting into the without
violence.
going to the violent part. So I think that's important to
Make
check
sure you
out.
talk over the music again.
Yeah, well, wide open spaces, not like the holes caused by an AR-15.
Oh,
Right? Those are small.
Oh, no.
Small open spaces.
Oh no.
The Dixie Chicks are clearly commenting from a point of ignorance about bullet wounds. I think that's what this song was actually about.
Give us the Minnesota version of, the Dixie Chicks made lots of crap music, don't you know?
Yeah, that too. Okay, here we go. Get off of my property. There it was. Did you
Oh,
guys
wait,
hear
I
it?
didn't hear it.
We didn't
no.
hear anything.
Okay.
You
Audio was
sharing
off,
that
I
with
think.
us?
Okay, here we go. Oh, it's the audio. Yeah, the audio
Yeah.
probably got turned off when I switched screens. Just a second.
We'll take your word for it.
No, I'm not going to take
No.
anyone's word for it.
No, I want everybody to hear it. You know, we're analyzing.
Yep.
Did you hear it that
Right there.
time?
Yep.
Yeah.
He wasn't. Okay, so, but the question is he even on his property at this point? Because he's not on the porch.
Well, he's
He
definitely on
probably
his
is.
property. I
He's
think
in
we
front of
def-
the.
almost certainly,
he's-
yes.
He
On
owns
the
that
property.
property. Yeah, he owns
Okay.
that property.
Okay.
Yeah, that's the yard. So that
He could
that-
use some maintenance, though. You know,
Look, this is Texas, man. It's
little
dry.
groundskeeping. You know.
It's Lubbock.
Yeah. Do we? Oh yeah. Lubbock, Texas.
Lubbock.
Yeah, that's a bit. I haven't been to Lubbock myself, but I have images from other people telling me
Look,
about it.
Everybody who's been to Lubbock would say I haven't been to Lubbock myself. I mean, that's just preservation. Okay, so now what I want to know is what Chad said to him there. I couldn't make it out. So he says, "Get off my property," and then he says something to Chad. Chad nods and goes into the house, and then he's turning or Kyle nods and goes into the house. But I don't know what he said there. I'm about to go get him. She says, this is about the kid. He says, I'll go get him because he's at the grandmother's house. Is that what you said? Legal bites?
So what he says
That's
later is that the cops are on their way to your mom's house. And she's like, well, why are they on the way to my mom's house? He's like, because that's probably where he is.
Okay. Here we go.
3:15. And you're playing games telling me that I can pick him up at 6? I'm going to have to call.
Again, I'm going to go up to the point of the shooting.
Because that's probably where he is. When I'm done working, I get him at 3:15. I get him at 3:15. I don't care if you wanted to see him or not. I get him at 3:15. If you want to see him, you see him up until 3:15.
We watched the other angle earlier, guys.
Son from me, I'm fixing to drag you and Anne Marie and everybody else into court. I'm subpoenaing your mom. I'm subpoenaing Anne Marie. On video. Yeah, I am.
Someone said, I'm glad this is on video.
Kyle said
Yeah.
that. Kyle says that when he comes
Yeah.
out the gun.
Okay. So he's got the gun down. He does pull the gun up into his hand, not pointed at him at this point.
Do it right. You better fucking use it.
Oh, he
Yeah,
He
I
went
think
to low
it-
ready.
no, but no, I think it made contact with him. Like the what's it called? The end of the gun made contact with him.
Barrel.
Well,
Let's-
yes,
let's
thank
check.
you. Thank you.
You better fucking use it, motherfucker.
I don't know if it did. It looked like he went from here and went kind of around down to low
Well,
ready.
Let's
We'll
try
do it
one more
again.
time.
And we also, by the way, you'll be alert that in a moment you're actually going to see Chad push his hand up a little bit, the hand that's holding the gun, that's supporting the gun, like as if he almost, if you're looking for the defense, let's look at both sides. You're looking for the defense. It's almost like he sort of pushes the gun around a little bit right before the warning shot. But
All right, here we go.
okay, there you go.
Please do it right. You better fucking use it.
I don't think the barrel makes contact.
Okay.
He switches to low ready before doing it. It does not look like he points it at him while switching to low ready. I've been looking to see if he does. I'll watch one more time to see if he does switch, if he like makes a pass on his way down, but I don't think so.
I'm subpoenaing Anne Marie. On video. Yeah, please do it right. You better fucking use it.
it's hard to tell.
Yeah,
It's hard to tell, but he says, leave right now. And then Teal Guy says, you better fucking use it or I'm going to take it from you and use it on you. Let's hear that audio. Cause I think discounting those words might be
that's true.
unwise.
Do it right. You better fucking use it, motherfucker. God damn it, I'll take it from you and fucking use it on you.
I'll take it from you
Yeah,
and use it
that's
on
a
you.
pretty.
I mean, you've got a clear threat of deadly force at that point. He still has not pointed at this. Plus, I do want to point out that the manlet is staring up at the tall Chad.
Yeah.
But yeah,
And the
I mean,
penal code has specific things about threats too.
Yeah, but it says that verbal threats are nothing. That's what it says.
Well, I don't know if I was having
Well,
trouble.
but if
parsing
we're
it
talking about I mean,
say verbal threats are
that
not
still goes to
provocation.
his state of mind, though. That still goes to his state of mind of whether he reasonably feared for imminent danger to his life or great bodily harm.
Someone says nipple to neck. Oh, the chat is not right. This is a serious situation. The chat. You're not allowed to make jokes.
That's
Only
great.
I am. Okay, so then again, I'm not gonna go to the shoot. I do want to see the warning shot.
Call 911. Call 911. Call.
He
did.
grabs
His
the
hand,
gun.
his
It
hand
ends.
does
It ends.
lift it a little
His
bit.
arm is underneath his hand. Go back. You'll see his arm is under his hand. He doesn't grip the gun with his fingers. His hand goes under his hand and like lifts it.
I mean, that might be a distinction without a difference under the law, but here,
Okay.
we'll watch.
Call 911.
See, he sort of pushes his arm up.
Yeah, I don't know if he touches
I mean,
the firearm or not.
it's the top of his hand. It's not, but I
He's
mean, if
using
we're
his
talking
wrist.
about if we're
He uses his
talking
forearm
about
to push him.
the state of mind of the potential defendant
Of
here,
Kyle, yeah.
it doesn't really matter. I mean, he's looking up. He's not looking down at his hand. He may just feel a movement that kind of pushes it up and says like,
He manipulated that gun. I mean, that's
Yikes.
Okay. I can
That's-
give you that.
again,
the
and
defense.
it's
No, I
not
understand.
this is not slam dunk.
We're
just
trying to
saying,
look
like-
Yeah.
at both sides. We're trying to look at both sides as
yeah,
fairly
we're
as
trying to work
possible.
through this here for
Yeah.
sure.
So here we
And
go.
that's a fair point for the defense.
Oh, sorry, I didn't mean to cut you off, Joe.
No, go ahead.
Here, we'll go back to here because I think he's right about the shoot, and I want to make sure the
Yeah.
audio catches it.
Call 911.
I'm sorry. Did you guys notice that nature called Kyle a chicken right there? And that's what provoked this encounter.
His real name is Marty McFly.
Exactly.
And he just got offended.
And-
There's nothing else that he could do about it.
God's like, do it. Here we go.
If that comes into the defense, man.
Here we go.
Call 911. Call 911. Call 911.
So there was
He
the
steps
warning
forward
shot.
afterwards.
There's the warning shot. Interesting. Like, it's almost like he very carefully made that warning, which, again, legal advice. Don't ever make a warning shot. Like, do not do it. I don't care what Binger and Krause said. Don't make a warning shot. If you're going to pull the trigger, you're using deadly force, even if you miss. Even if you intentionally miss, you're using deadly force. So, but here we go.
Call 911.
Hand on the gun there
Yes.
for
Yeah.
sure.
But
then
flinging
I'm-
him away, he's definitely
Yep.
flinging him away.
Yeah. But I'm not going to watch anymore
Yeah.
because of the.
I will
Yeah,
tell
yeah,
you, he
yeah.
takes a half jump back. He takes a half jump back before he fires. Also,
Yeah.
I don't know if this helps for you airing it. At the moment he fires, you can't see you can't see Chad in the frame. You
Yeah,
see him ready, aim. I don't want to get your channel in
Eh.
trouble. I'm just telling
Yeah.
you I'm telling you how
I think
it breaks down.
I think we've got enough. And yeah, I agree with you. He takes a half step back. He does. I mean, he levels the rifle. There is some level of delay there. It's fast. It is fast, but it's not instant. And so that's going to be a question. One thing I want to go to on this. Okay,
So
here's the-
self-defense.
I want to get to this because habitation is going to maybe matter, right?
Self-defense is 9.31 and deadly use of self-defense is 9.32.
So I want to get to the habitation definitions in this chapter. Habitation means a structure or vehicle that is adapted for the overnight accommodation of persons and includes each separately secured or occupied portion of the structure or vehicle and each structure appurtenant to or
Yeah.
connected with the structure or vehicle.
So that would be the porch.
The perch qualifies as a habitation.
But
Yes.
not right outside the porch. So when he tells him to
No.
leave, he's not in his habitation because he was standing on the ground, not on the
On the-
porch when
on
he
the
says
front
you
yard.
need to leave. Yeah. So
Yeah.
Right.
he's not in the habitation. I agree with you all. The porch is part of the habitation, but the front right
So-
below the porch is not.
Yeah, I
We
agree.
need threats is justifiable force. The threat of force is justified when the use of force is justified by the chapter.
Okay.
Okay, here we go. So justification generally, public duty.
Necessity.
Except as qualified by subsections B and C, conduct is justified if the actor reasonably believes the conduct is required or authorized by law, by the judgment or order of a competent court, or in the execution of legal process. This one doesn't apply here. So
Let's go to
necessity. Conduct is justified if the actor reasonably believes the conduct is immediately necessary to avoid imminent harm. The desirability and urgency of avoiding the harm clearly outweigh, according to ordinary standards of reasonableness, the harm sought to be prevented by the law prescribing the conduct, and the legislative purpose to exclude the justification claim for the conduct does not otherwise plainly appear. I'm not sure if that section is going to
I don't
apply.
think that really
necessity
applies.
is more like a dog is chasing me. I jump onto a car and I damage your car by jumping onto it. There's a necessity there where I'm protecting myself.
Right.
And I'm defended under the law for doing that, taking that action.
Yeah. So I don't think necessity applies. So now we go on to protection of persons.
Oof.
Self-defense.
This is a
Is there a
long
protection of
section.
property section?
Yes, there is. That's 9.41 or
Okay, that's
9.42.
down here, subchapter D. So
Yeah.
we'll get there.
Yeah.
So here's protection of persons. So self-defense, except as provided in subsection B, a person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. The actor's belief that the force was immediately necessary as described by this section is presumed to be reasonable if the actor knew or had reason to believe the person against whom the force was used unlawfully and with force entered or was attempting to enter unlawfully and with force the actor's occupied habitation, vehicle, or place of business or employment.
Technically, he did tell him to go away. He did enter the habitation.
Yes. And remember that the habitation as defined by the statute includes any appurtenance attached to it.
So the porch.
That would be the porch.
Yeah.
Unlawfully and with force removed or was attempting to remove unlawfully with force the actor from the actor's habitation, which he does do.
You're saying unlawfully and with force. Is he coming in there with force?
I don't know how they define with force.
That's a good question.
Yeah.
But B, let's go to B. Unlawfully and with force removed or was attempting to remove unlawfully with force the actor from the actor's habitation, which does happen there.
That's exactly what we have. When he flings him away, that's what I believe he's right. I think that he has a right to self-defense the moment Chad flings him away, but this is regular self-defense, like with your hands, not deadly use of self-defense. So 9.31,
that's the next section.
That's what I think is 9.31B. 1B is where Kyle acquires a right to self-defense under this. And I think 9.31 attaches to him. And he can say, which is an element to 9.32.
Man, I don't know. I think he has it under A when the guy enters the property, but it depends on how they define with force under case law. And that I don't know. I don't know. But so then C was committing or attempting to commit aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. I don't think we can say any of those are true. Although, no, not robbery. Burglary, maybe, but not robbery. Okay, so did not provoke the person against whom the force was used. So there is a provocation section here. Was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of law or ordinance to regulating traffic. I don't think that applies. So the use of force against another is not justified in response to verbal provocation alone.
So we can throw that out.
That's what, yep.
To resist that's verbal provocation alone, but do you combine the verbal provocation with the entry onto the property, with the entry into a space?
Yeah.
There is physical contact.
It's also, you have to recognize, it's not entry onto the property. He comes there legally.
Entry into the habitation, sorry.
He comes there legally, and then all of a sudden, when you say leave, and the guy has to leave, it's not like as soon as the person says leave, now I'm illegally standing here the next millisecond after the guy says leave.
No, it literally does mean that. Like
I think it becomes
you have a reasonable time to leave, but he doesn't make any movement to leave.
Agreed with you. And I think when you look up criminal trespass, that's what we will see that Chad has violated. I'm not going to have time to stick around for this. Like I said, I got my Sabbath starting. I got to fly now. I'll just wait. I'll weigh in for you guys. I spent an hour on my Discord chat going through this with several of my subs. My finding, you guys can come to a different conclusion. My finding is that he's not going to get up. He's not going to attain a right to self-defense, deadly use of self-defense. Because he doesn't have any of the other crimes that are going on there or just happened there, which is what you need for deadly use of self-defense. I also believe when you go down to the defense of property, he'll have exact same problem on defensive property. And I cannot believe this guy was in charge yet. To me, this is This was outright murder under Texan law. Forget about my personal thoughts about it, which on morality, purely Texan law. It's astonishing to me that he hasn't been arrested yet, because this guy, my take is under Texan law, he's a murderer. I do need to go now. I will ask you guys if you can try and just sign up to my channel a little bit. Give me a little bit of love. I don't just give you brilliant legal insight. I will make you laugh. So just try and do that every once in a while.
Everybody's channel is in the description. You can definitely check out Joe. Joe, I bid you farewell, brother.
It's great seeing all of you. Thanks for having me on, Nick, and I'll see you guys soon. Take care.
See
Have
you,
a great
Joe.
weekend. Bye.
See ya. Okay. And someone said I should redo the poll. We'll do it when the analysis is done with this. We'll redo the poll and talk about the upcoming Kim Potter trial. And we'll let the poll run during that and see if people change their minds. It'll be interesting. Okay. So back to this thing. So here we go. Where were we? Okay. Here, did not provoke, was not otherwise engaged. The use of force against another is not justified in response to verbal provocation or to resist an arrest or search that the actor knows is being made by a peace officer.
Not
I don't think that applies here. If the actor consented to the exact force used or attempted by the other. So, yep. So you say, well, that'd be Rosenbaum, right? Shoot me, Nibba, or whatever. Then he gets shot. If the actor provoked the other's use or attempted use of unlawful force, unless the actor abandons the encounter or clearly communicates to the other his intent to do so, reasonably believing he cannot safely abandon the encounter, and the other nevertheless continues or attempts to use unlawful force against the actor.
No abandonment.
I didn't see any de-escalation there. If the
So
actor,
back to if it provoked. Okay.
if the actor sought an explanation from or discussion with the other person concerning the actor's differences with the other person while the actor was carrying a weapon in violation of the law or possessing or transporting,
that actually might technically apply in some way.
Wait, sorry. Which section are you reading right now?
5 here.
Okay.
If the actor sought an explanation from or discussion with the other person concerning the actor's differences with the other person while the actor, I think what this means is, hey bro, I just want to talk. I have this gun, but I just want to talk about our issues. I don't know that this is in context of, but it is kind of funny because they did exchange words. So maybe he loses if you say anything other than
discussion of differences.
But you have to be in violation of section 4602 or possessing or transporting a weapon in violation of 4605. I mean, maybe he was unlawfully in possession of the gun, but I don't know that we have any info on that yet. So the use of force to resist an arrest or search is justified. This isn't an arrest or search, probably. The use of, use of deadly force is not justified under this subchapter text, except as provided in sections 932, 33, and 34. Person who has the right to be present at a location where the force is used, who has not provoked the person against whom the force is used, and who is not engaged in criminal activity at the time force is used, is not required to retreat before using force, as described in this section. So stand your ground. For purposes of subsection A and determining whether an actor is described by subsection E, reasonably believe the use of force was necessary, finder of fact may not consider whether the actor failed to retreat. So that's more stand your ground. So Kyle has no duty to back off ever in this case. Deadly force in defense of person. So this is one of the possible. There are 3 possible deadly forces. Justified in using deadly force against another if the actor would be justified in using force against the other under section 9.31 and. So you have to meet the first part. And A, to protect the actor against the other's use or attempted use of unlawful deadly force, or to prevent the other's imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. So this is the question here. Does he believe that he is basically in danger of deadly force, right? Like, are we in agreement on that? That seems to be the issue. Unless, murder is going to be the same thing. I don't see an aggravated kidnapping or sexual assault. Maybe.
No.
Maybe Chad was giving him the eyes, though. Do we consider?
No.
I'm joking.
Just no.
All right.
Yeah. There's nothing. I mean, well, so the one thing that you can say that green shirt man was sorry. Whoa. Hang on. I'm busy here. The one thing that you can say is, I mean, him reaching for the gun, like that's the potential deadly force.
Okay, here we go.
That we can be looking at. Oh,
but this is interesting. The actor's belief under subsection A2 that the deadly force was immediately necessary as described is presumed reasonable if the actor knew or had reason to believe that the person against whom the deadly force was used unlawfully and with force entered or was attempting to enter unlawfully and with force the actor's occupied habitation. He is told to leave the property and he goes onto the porch. Yeah. That is unlawful. The question is with force.
But then what about the fact that, what about the possibility of provocation before he goes onto the porch?
And then here we go. Actually, he's got it here. Unlawfully and with force removed or was attempting to remove unlawfully and with force the actor from the actor's habitation. I mean, that, but
the question is, the points leading up to the green shirt guy, that's Chad, right? Yeah, that's his name. So the point leading up to Chad stepping onto the porch, like several things had happened. Kyle had gone in to the house, come back out with a gun, and then also shot at the ground. No, sorry, that happened on the porch already. The ground
happens later.
No, that's right. That's right. You're right.
So he might be justified in the warning shot even. That's deadly force. But
the fact that it's at a different time might be a problem too, because the use of the force wasn't occurring when they were attempting to be removed. At the time they were on the porch, like that kind of was over now. So maybe there's a sequence break.
So with the caveat that I don't know what with force means under this law, and I'll be doing some research on it to try and figure out under case law what that means. I say I'm on team Kyle here. Now, I don't want anybody shot. I really don't. I think this is all around a very tragic situation. Should not have happened. And probably mistakes are made on both sides. But under the law, I'm going to say that he unlawfully enters without question the habitation. And I say with force, he does so because he does so with something that would be a battery or an assault under Texas law. And that is, he gets right up on the guy. It's an unwanted touching. And I think at that point, I think he is justified because that guy has to me, no amount of provocation amounts to unlawfully entering the domicile or the habitation. I cannot figure out where nothing we see in this video would say that he should enter onto that that habitation and utilize any level of force at all. I just can't see it. He also does make a threat of violence when he does so, but that's a question. I'm on team Kyle at this point.
Then we got subpart 3 where he also has to not be otherwise engaged in criminal activity, which might be a problem potentially on earlier incidences in the sequence.
What okay, so let's move on. And we'll get to that. So was committing or attempting to commit an offense described by subsection A2B, which I don't think A2B applies. So we can ignore that. So did not provoke the person against whom the force was used. So the question
is that's debatable for sure.
Does he provoke and was not otherwise engaged in criminal activity other than class C misdemeanor? So was Kyle engaged in a criminal activity of some sort up to that point? And let me suggest my review is this, okay? And please correct me if I missed something. That would be criminal activity. Kyle is out there. Chad is on the lawn. Kyle says, "You need to leave," and then goes to retrieve the firearm from the house. He comes back out. He has the firearm. He says, "You need to leave right now." And then the guy enters onto the porch at that point and says you better fucking use it or I'm going to take it from you and use it on you. Right? Like,
Mhm.
did I miss any potentially unlawful activity there? Assuming that the gun is legally possessible by this guy, which I'm since I don't have information to the contrary.
Right.
Yeah, I don't see anything.
Okay.
I mean, so the one thing that I'm kind of thinking of possibly is, I mean, every time you see an Amber Alert, I mean, not every time, but most of the times when you see an Amber Alert, it's usually one of the parents absconding with the kids. And so, you know, that technically, I mean, I think could be kidnapping, right?
No, you're not going to get you're not in any way going to get criminal kidnapping in a custody dispute
No.
of children.
Yeah.
And trust me, I've
yeah.
tried. I've tried to do this because I had a case where a guy was unauthorized to have the kid, had no legal right to have the kid, and held the kid for 3 months across state lines despite repeated requests to return the child. There and this is in the absence of a custody agreement where under the law, the presumed custody agreement is 100% with the mother, as the two were unmarried at the time. And the father had zero contact with the child prior to this. So, I mean, we've got if that's not a case of kidnapping, you've got cross state lines, you've got 3 months of time, consistent complaints to the authorities about it. And they all said, no way we're getting involved in this. It's civil. So I don't think you get criminal kidnapping.
Okay. That's fair.
Out of this. All right.
Yeah.
Someone said that the links are not in the description. They are. They're under invoice. There's in all caps. And then there are the @ for the different people. I've tagged them so that 2 things happen. It tags their channel. I don't know if that has any back end thing, but it also notifies my guests that they are tagged in the video as it releases. The other thing it does is it allows you to hover over those little @ uncivil law, legal bites, and good logic. Click on them and go right to their page. So they are in there under invoice. Okay. So next, this is just stand your ground. No duty to retreat. Same thing as before. So I don't think there's no retreating that happened here. I guess there could be a duty to retreat if the provocation occurs, but if the provocation occurs, we're already losing the deadly force, right? Are we in agreement on that?
Yes.
So in other words, if Kyle is the one that has provoked it,
then he would have a duty to retreat.
that sounds about right.
Although the interesting question, duty to retreat mixing with castle doctrine, I don't know. This is just has he retreated by remaining in his habitation under Texas law?
No, I don't think so.
Because under castle doctrine, you have no duty to retreat within your habitation. So I don't know how that plays out. That's an interesting, just a thought experiment for people to mull over, and a place. And the reason I bring up thought experiments is as a criminal defense attorney or a criminal prosecutor, places for weird ambiguity like that make room for novel questions of law for a court to determine and to then go to appeals to change the way that the law can be applied in future scenarios.
Right.
So I don't know if Texas has resolved this question of whether or not you have a duty to retreat within your property. Under castle doctrine, you typically would not. So if you're already in your property, do you have a duty to retreat further into your property if you use provocation? I'm not sure. Or do you just lose the right? I have no idea. All right. So defensive third person, I don't think this applies, right? He's not defending a third person. It would be unreasonable to assert he is, in my opinion, if you guys disagree.
Sorry, unreasonable to assert what?
That a defense of a third person.
Yeah.
Okay. So protection of life or health. A person is justified in using force, but not deadly force against another when and to the degree he reasonably believes the force is immediately necessary to prevent. Okay. Not deadly force. That's not important here. Protection of property. A person in lawful possession of land or tangible movable property is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to prevent or terminate the other's trespass on the land or unlawful interference with the property. Here's deadly force to protect property coming up. Okay. So then terminating the other's trespass on the land or unlawful interference. I think he would have that. He has told him to leave multiple times.
Wow.
The question is, do we get to deadly force?
Look at 942-2B, man. You can shoot someone in the back.
Yes. Texas
Wow.
That's pretty
takes
nuts.
property protection more seriously than just about any other state. That's what I was saying earlier. So unlawfully dispossessed of land or tangible property by another is justified in using force. I don't think he's unlawfully dispossessed, right? Okay, so deadly force to protect property. Justified in using deadly force against another to protect land or tangible movable property if he would be justified in using force against the other under subsection 9.41. I think he is to terminate a trespass. But the question is, and here. To prevent the other's imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime.
No.
Burglary, though. Burglary is entering a property unlawfully and committing another criminal act while in the property, while it's occupied.
Is it that the criminal act just has to occur, or does the two have to be more linked? Like you're entering the property for the purpose of committing a crime therein.
Let me check. Texas statute burglary. Burglary of habitation. Penal Code, Chapter 30. This is where we get the habitation.
Thanks for this bar exam question. This is great.
This is a tough question. I love this. Burglary. A person commits an offense if, without the effective consent of the owner, the person enters a habitation or a building not then open to the public with the intent to commit a felony, theft, or an assault, or remains concealed with the intent to commit a felony, theft, or an assault in the building or habitation, or enters the building or habitation, commits or attempts to commit a felony, theft, or an assault. Enter means to intrude any part of the body or any physical object connected with the body. An offense under this section is a state jail felony, blah, blah, blah. That's it.
So burglary might apply?
I think he commits an assault, man. If someone comes up, like, ignore the deadly force response to the assault. If someone comes up to you and does and puffs his chest out and bumps into you and says the threat, right?
But the threat is nothing. We learned that from earlier, didn't we?
I don't know that. No, it just says verbal threats on their own are not sufficient for deadly force.
Fair enough. I stand corrected.
Or I think for any force.
Yeah.
So, man, I think that's. I think he's got it again. I mean, I look at this and I say, that's burglary. What Chad does at that point is burglary. Any portion of the body intrudes onto the habitation, which it's the same statute. The burglary, I didn't pull it up because it's annoying, but the burglary statute is section 30.
Oh, no. There's this very small technical difference here that makes a difference. If you go back to the burglary statute,
yeah.
In part 1, it says habitation or building. In part 3, it just, maybe I'm wrong. Enters a building or habitation and attempts to commit or commits a felony. So your idea is that he entered the porch, which is the habitation, and he committed a felony, theft, or assault. And the assault is him puffing his chest up. Maybe. You might be right.
And making physical contact. And then later touching the gun. That's another question. And then he definitely makes an assault when he grabs him and flings him off the property, right? Like,
yeah, I mean, I'd have to concede that much, and then we just get into a proximity issue on time frames, but that would certainly be an assault. Yeah, because one of the issues also, of course, is the degree to which the deadly force is in response to that stuff, which
Someone says he was not in the habitation when he was murdered. I think he was still on the porch when he was shot, because otherwise you would have to concede that he walked towards Kyle, which I don't think actually happened. I think Joe's right. He stays stationary, but he's within the property at the time.
So let me just go back to the sequence. So we had this warning shot, and then we had a struggle for the gun, and that was when he got threw off the porch. Is that correct?
Yeah. Yeah, he gets
And then
flung off
as-
the porch.
And then as part of that fight, then the fatal discharge occurred.
Yes. Or right after. Right. So he gets thrown out. He kind of hops back and sets himself and then takes the shot. 2 shots.
He might be able to squeeze himself into this statute.
It's a tough case, but
It's a tough case, but it might work.
Wait a minute. Okay, no. So here, yeah. So then here there is an and here as we go on.
Oh, there's more?
Yes. So you
Great.
have to fit A or B, and you have to go to, A or B, and you have to go to 3. Reason believes that the land or property cannot be protected or recovered by any other means, or
No.
use of force other than deadly force to protect or recover the land or property would expose the actor to another to a substantial risk of death or serious bodily injury.
He's not really trying to recover the property or really protect the property, is he?
Right. So A, I think, does not apply. So then the question, to recover the land or property.
Yeah, I mean, he's not really trying to recover the land or property, is he? I mean, that's a tough squeeze.
No,
Is
the
he trying to
question
recover
is,
the land or property?
I mean, re-entering your property. He's been alienated from his property at this point. Is re-enter recovery? Because it's land or property.
And then
so
he
you can't
says, but
physically remove
then
land.
also, even if you have that part, then the use of force other than deadly force would provide substantial risk of death or serious bodily injury. So we have to pose the guy shot is posing a risk of death or serious bodily injury. I mean, he did say that he'd take the gun and shoot him, but
the question is whether use of force other than deadly force would pose. So in the alternative to shooting, if he used some other level of force to re-enter the property, would he then be exposed to risk of death or serious bodily injury? That's a tough question.
no. I don't know what the answer is.
So he might not be under the deadly force to protect property. I think he's under self-defense here because he was thrown off of his habitation, which was up above in the self-defense statute.
In response to the warning shot, right? Because the warning shot came first, then it was thrown off the habitation.
But the
so
question
now we're back
is,
to the warning shot and whether the warning shot is justified. So now we have to determine that.
yeah,
And whether that shot was justified.
it's tough, man.
Right. Because because we have to keep going back through the timeline to figure out who the first bad actor is, who's the first person to use lethal force. The statute does seem quite clear, though, that the mere threat, and whether or not this is mere threat, because as you point out, there are other things, but the mere threat alone is not deadly force. So the mere threat to use deadly force is not deadly force. The statute seems
So
clear on that.
if someone just says, "I'm going to kill you,"
Yeah.
that's not sufficient to respond by killing them.
It's considered non-deadly force at that point. It's force, but non-deadly force. So you'd be justified in responding with non-deadly force, the way I read the statute.
So Atheist for the Cause says, please talk about the initial gun brandishing. I want to be very clear.
Yeah.
I did not see any brandishing prior to the warning shot. Brandishing under the law means to wave at or point a gun in a threatening manner. And
Can we go back to the video and watch the stuff that was going up to the warning shot to see where some justification might be?
Okay, so I brought it back to prior to the gun even being out, so we can get the full view. Dixie Chicks really like shootings. They keep playing their songs during these shootings. Okay, sorry, I was talking. So that was the point where he says, "Get off my property," and I don't know what Chad says to him there, and that bothers me.
Now, at this point, there's no threat at this point. They're having a confrontation, but there's no threat of violence up to this point. I think that much is true.
Yep. Okay, so we're about to get, but I am curious what he said, right? Because he said you need to get off my property. He says something, and Chad shakes his head and then goes inside. So here, let's. I don't think we're gonna hear it, but I just want to point that out. Could you make anything out on that?
No.
Okay, me either. So that's going to remain a mystery. That'll rely on Kyle's testimony and his ex-wife's testimony, which is probably not going to be beneficial for Teal Guy. So here we go. Yes, Sarah Marie, we watched the other video earlier.
Which showed me at least a whole lot of nothing.
Yeah, it does not show much, but you do see Chad collapse to the ground, and that was like the more explicit one, and I don't really want to revisit it because of how YouTube handles these things, but you are welcome to rewind and check it out or catch it on the replay and watch it as many times as you need to make your opinion. Goat account says it sounds like he said, I have a right to be here, as if in to get his kid. Maybe that's what he said. I don't know. I can't make anything out, but
yeah, I can hear it.
I'll listen to it on max volume later. All right, here we go.
I'll go get him. I'm supposed to have him at 3:15. And you're playing the game. You don't need that. I can pick him up at 6.
I want to address this real quick. Phoenix Rises 2014 says, what strikes me about this is how Kyle stands over him and talks like nothing to him, or like it's nothing to him, sociopathic behavior. I want to point out that the guy's girlfriend who's recording does the exact same thing. She carries on with a petty argument.
Yeah, they continue on with the argument like nothing happened. It's a weird thing.
I think it's shock, actually, on both of their things. I wouldn't read. I mean, a jury might read into it, but I wouldn't read too much into it either way, because the current girlfriend of Chad, she doesn't scream or say like, oh my God, what have you done? Like, there's no reaction. He's just turns into an object at that point. It's very, very awkward. And I think it has to do with just the shock of the situation. And people are maybe just in disbelief, but I cannot imagine like that happening. Even if I didn't know the guy, like that happening right next to me, me not being like, the hell, like there's a dead body here. It's crazy. All right, here we go.
I'm going to have the cops. I've already got the cops on the way to your mom's house. Because that's probably where he is. It's not when I'm done working. I get him at 3:15. I get him at 3:15. I don't care if you wanted to see him or not. I get him at 3:15. If you want to see him, you see him up until 3:15. You keep trying to keep my son from me. I'm fixing to drag you and Anne-Marie and everybody else into court. I'm subpoenaing your mom. I'm subpoenaing Anne-Marie. On video. I'm very please do it right now. You better fucking use it, motherfucker. God damn it, I'll take it from.
Okay. Lost Bullets in the chat mentioned that there was brandishing right when he came out. I didn't see it. He goes, he has the gun. He puts it up into his hand. But a brandish, again, is waving the gun, typically pointing the gun at someone in a threatening manner. Having it, I mean, he's got it at a high ready position, I guess. I don't think that's a brandish under the law. I guess I could check the Texas code.
I don't think it's a brandish.
Yeah, because I've been looking. I'm like, where is brandishing? Brandish is not even listed in Texas code.
Nice.
Under weapons. So I don't know that we're gonna get there in any way. I think you have to actually in Texas threaten someone with the weapon.
Your mic just went really weird for their.
Mine did?
Yeah. I think it's fine now.
Oh, cool.
What did I miss?
We're rewatching it, trying to figure out if we can squeeze any of this into the statute. We're trying to figure. I think at the moment we're trying to figure out like who the first bad actor is and where the first.
Yeah.
Okay.
Violent for the first deadly forces in this equation.
All right, here we go. So right now he's walking out with the gun.
Yeah, please do it. Right, you better fucking use it, motherfucker. God damn it, I'll take it from you and fucking use it.
Call the police.
I cannot see how that's not a battery or well, I think Texas just calls battery assault under the under their criminal statute. That's gotta be. Let me. We can check the Texas assault code real quick.
It's an assault. He's in the habitation.
Assaultive offenses. Person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another, threatens another with imminent bodily injury. I mean, intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative.
You're there.
Yeah, you're in the statute on at least 2, in my opinion, because threatens another with imminent bodily injury. The second he says you better use it or I'm going to take it and use it on you, that's a threat.
Yeah.
I mean,
and it's more than just words because he's actually in his physical space, right? He's actually touching him. So that those details combined, I mean, yeah, it definitely significantly elevates the situation.
Okay, but the reason we care about it being an assault is because whether or not it's a burglary, which we only care about to the extent we're trying to protect property, right?
Sort of. I also think that an assault is necessarily provocation. Right?
Well, I think assault would be provocation to equal force. So a non-deadly force respond with non-deadly force, I think. So it's a provocation to non-deadly force, I would think, but not more.
Yeah, that's a good point. Oh God, now I'm gonna have to like pour over these statutes to try and figure this again. And that's it's going to the point I made earlier. This is not an easy case under any stretch, and anybody telling you it's clear cut one way or the other, I don't think it is. I think this guy, if he does get charged, even if he's justified or not, either side is going to have to make they're going to have to make a showing on this. That's ignoring the political aspect of this, that the shooter is politically connected, apparently in Lubbock, and might be being shielded by some shady stuff. In fact, I believe the Lubbock district attorney has recused himself on this issue because he knows the guy. That's a whole separate issue. And this may never see a courtroom at all because of that. But the public outrage over it might also push back on that pressure. So I don't know. But if it does go to court, I mean, this is not an easy case, and either side would be nervous about this one, I think. Okay. Should we go on?
Yeah, a little bit.
Okay.
Call 911. Call 911. Call 911. Call 911.
Okay, that's all as much as I need to see. I just was waiting to see what happened prior to.
I'm trying to stop it. Here we go. Back.
Yeah, I was just trying to wait to see what happened up to the warning shot. And also, like, whether or not his hand actually touched the gun or not, the movement could be perceived as him going for the gun.
Right.
So
even if he's like,
gesture,
if it's like the top of his, like an argument might be made that it's like the top of his hand versus like kind of like in football for like a pass interference,
they tried to do it with Kyle, right?
But
like he tried to do it with Kyle, that he was going like this or something to stop the gun rather than reach on it. It's an unconvincing argument typically.
But yeah, I mean, if we we refocus the analysis to the defendant's state of mind, where is he looking? What is he reasonably feeling, perceiving? He's got this big guy that he's looking up to, and his hands down here, and he feels this big guy's hand or arm moving his gun, any kind of a movement on it. He could reasonably perceive that to be he's trying to take it from me right after he told me that he was going to take it from me and use it on me.
Yeah.
So I can see that too.
I think I'm on team. I'm on team indeterminate. There's some real factual questions here about what the jury has to resolve about what was in people's minds and what they perceived and stuff. So I don't know that at least for me, I can draw a conclusion at this time either way.
I'm gonna be contrary. I'm gonna say I'm on team justified. I think there are caveats that can make that wrong, for sure. But I'm leaning towards justified shoot. That's where I'm going on this one. I think under Texas law, and the way that they have allowed protection of person and property with firearms, I think the cards are going to fall in Kyle's favor. I don't think it's an easy case.
There is a path to get there. I
Yeah.
don't think I disagree with you that there's a path to get there. I'm just a little bit unsure about whether or not jury
I
will
would
walk
be-
that path or should walk that path as
I
a
would
matter
be
of
cur-
factual
I would-
realities.
I would be curious about previous interactions that they had that
That too.
got heated and that didn't get heated. Because like what other kinds of maybe there were threats that were leveled before, you know, were there any physical altercations before this point that between them
Yeah.
that obviously didn't involve lethal force. I would be very, very curious to learn that kind of information that might help to contextualize one way or another.
Yeah, that would be very interesting if there was like a report of a prior threat with the firearm from Kyle. If there were text messages between Kyle and Chad that with some heated words exchanged, something that you could say that the mere act of grabbing the gun was specifically provocative.
Yeah.
I think then you can get away from it. Right now, I mean, for me, I think it's justified. With that, I'm going to redo the poll with a justified versus unjustified thing now that people have walked through our
versus
legal
none of the above, maybe.
But I can still see, like, if this were a jury, I mean, just kind of going through my own logic versus my own emotions right now, I can still see how a jury would hear the defense's case on this and you know, logically this should go towards the defense, but still say this guy was there to pick up his kid. He's like very upset about the fact that he's just trying to see his kid, you know, like, and then he gets killed because of it. I can still kind of see somebody emotionally saying like that it was still
You close
murder,
the poll
you know, for
immediately.
those.
I wanted to add a not sure.
Okay, none of the above option. Yeah, 'cause
okay.
that's like
I'm
you
reopening it
unfortunately
right
choose.
now.
I can still see how somebody emotionally would just say, you know, I don't care that much. This guy died and this guy killed him and it was very quick and it was, you know, like, I don't know.
Okay, the poll is going up right now. So yeah, again, very close case. And when I say I'm leaning justified, I am 100% willing to be convinced. I think the force question, because the self-defense means you have to enter with force, right? That force question matters. What does force mean under that specific statute? I don't know. Not an expert in Texas self-defense law or anything like that. So this is a very close case. I lean justified under Texas law. Should this shooting have happened? No. This is something that did not need to happen. That guy did not need to die while trying to get his kid back. And let's talk about the real villain here, and that's the family court. The family court is, and I mean this without a hint of irony or jokery, the family court is a plague and a pox on society. And I think it is responsible for a significant amount of violence and probably a very significant amount of actual deaths in situations similar to this, or in cases of suicide and stuff like that, through just what happens in the family court.
Even the lawyers in family court. That's the one case that I have ever heard of any lawyer that I personally knew who said she worked in family law, and she said that she needed for a period of time to wear a bulletproof vest in Los Angeles. So not in a big gun state like Texas, but in Los Angeles, saying she needed to wear a bulletproof vest because of her own client, not because of the other side.
Yeah.
And
yeah,
that was family law.
I would
the
drop
only
the client
place
at
that
that point. It's like I can't help you out anymore.
I don't remember what exactly happened from that point, but I just remember her talking about it. Yeah, she apparently got word from the shrink who said, "Hey, you know, just so you know,"
Ooh,
she said some
warning.
she said some very threatening things, and you need to know.
Yeah, I've only done a couple family cases. One, I represented a mother in a custody case, and you know, the dad just was not in. he was not interested in the child. He was interested in punishing the mother. That was very clear because he did not exercise parenting time ever. The other custody case that the other family law case I was involved in involved actually getting a protective order against an abusive dad, who only seemed to be interested in the kid when his parents made him do it. He was your typical neat, in the fact that he had very wealthy parents and had no anything other than DUIs. Like that was literally all he had to his name, DUIs, no job or anything. And his parents would force him to exercise parenting time. And when they were not around, he would not do it. But when he did exercise parenting time, we had 8 years of documented abuse. And so getting that child out of that situation was critical. So with that though, like I don't engage in family court. I knew people in both of those instances. That's why I helped. But I think that family court is a pox, and it is extremely dangerous because that's someone's kids, right?
Yeah.
I mean, hell, Kyle was willing to kill to protect his girlfriend's ex-boyfriend's kids or whatever, right? Like, it's an extremely sensitive scenario, and I think the way the court's structured is a mess. But it's time to quickly talk about a different topic. If you guys are ready, are we done with this?
Yeah,
one?
I'm very ready to talk about something else.
So
Well,
I am probably actually going to be getting going.
Yeah, that's
because it's a little late for me.
Yeah.
I can't stay up until 4 a.m. every night like I did during the Kyle Rittenhouse trial. But yeah, no, this has been wonderful. Thank you so much for having me on.
Of course.
And this has been a really, really interesting to dig into this case with you guys. I love this, like just all kind of working through it together, looking at the facts and the law.
Yeah. And it's I love it for the chat because it's what we do, right? We take a thing and we watch it and read it, read and read and read and argue and argue and argue with yourself and with others to try and figure out, am I wrong? No, it's the children who are wrong. And that's the lawyer process. So I think it's great.
Yeah, absolutely.
But yes, everybody check out Legal Bites' channel. She's linked in the description. Just click on her name and it'll take you right there. Thanks for joining us.
Of course. Thanks so much for having me. And I'll see you in one of the next live streams.
Sounds great.
Okay.
Have a good one.
See ya.
Bye. Okay. Now to talk about a completely different scenario. Kim Potter.
Okay.
Up in Minnesota. You remember her?
Remind me.
Taser, taser, taser. Oh shit, I shot him.
Oh, yes.
Yeah, her trial starts on Tuesday and will be televised. So I'm going to do it. I'm going to do the trial.
Okay. Well, I'm probably actually going to have to work. So, but I'll try to see if I can pop in at all.
But yeah, so I'll be doing that. By the way, to the chat, you can find I'm going to do what we did with Rittenhouse, the trial of Kim Potter here on YouTube. So we'll be watching it. Hopefully members of the law panel will be able to join me. But that's the judge just allowed 2 weeks ago cameras in the courtroom because at first was not going to. You do not have a right to cameras in the courtroom in Minnesota. You have to get permission from the judge, and I believe it was initially denied, but 2 weeks ago it was. So I've got the video of the body cam footage.
What are the charges applying?
Oh, let me pull that up real quick. That'd be a good thing.
What are we on trial for exactly?
I think it's manslaughter, but let's see. Minnesota courts. They did amend the complaint from the original. So I want to check. Let's see. Access case records. Nope. Media. Covering cases, high profile cases. Potter. Complaint. The amended complaint was September 2nd, and I'm pulling it up here. We've got a couple counts. Let's take a peek, shall we? Okay, and we'll read their probable cause statement and watch the video. I think that makes sense. Does that make sense to you?
Yep.
Complainant submits the complaint blah, blah, blah. First degree manslaughter predicated on reckless use and handling of a firearm. So
Okay.
we've got 609.20 sub 2. The reference is a penalty fine. So we've got first degree manslaughter on or about April 11th in Brooklyn Center, Hennepin County, Minnesota. Defendant Kimberly Ann Potter caused the death of Daunte Demetrius Wright while committing the misdemeanor offense of reckless handling or use of a firearm so as to endanger the safety of another with such force and violence that death or great bodily injury or to any persons was reasonably foreseeable. Okay. So then the question becomes, does she fall under that reckless handling statute? Second degree manslaughter, 609.205, on or about April 11th, by her culpable negligence, whereby she created an unreasonable risk and consciously took a chance of causing death or great bodily harm to Daunte Demetrius Wright while using or possessing a firearm. That, at first blush, that seems weak to me on that one.
They both seem a little weak to me in my mind.
Yes. The big question in this case to me, and where I'm going is as a defense attorney for this police officer, and heaven forbid I'm ever a defense attorney for a police officer. No, I'm just kidding. But heaven forbid I have to do a murder trial ever. Would she have been otherwise justified in using deadly force? I think is a big question here. Because she says taser. She seems to intend to reach for the taser, but she instead reaches across to the other side of her body, pulls a gun, and fires.
Yeah.
But if she's justified in using deadly force as a peace officer in this instance, can it be negligent to use deadly force by mistake?
I don't think so.
I don't think so either. Like the mere fact that she says taser and pulls the gun should not obviate her.
I mean,
use
the answer there seems because there's no breach of duty. Because if you have the ability to use deadly force, then you didn't breach your duty by using deadly force. So even if you did it sloppily, I don't think you have the first element.
So
support.
Kurt's talking about breaching duty because that is an element of negligence. Negligence, you have to have the duty, then you have to breach the duty. Then the harm has to be caused by the breach of duty, and that harm needs to typically be reasonably foreseeable in the event of the breach, right?
Yep.
Well, and then damages, of course, in civil suits.
Yeah.
But yeah, so those are the elements of negligence. That's why we're talking about here. So Complainant Assistant Special Agent in Charge, ASAC, Charles Phil, is employed by Minnesota Bureau of Criminal Apprehension. In that capacity, Phil and SSA Sam McGinnis have reviewed reports and body-worn camera footage and gathered additional evidence. Okay, based on that, here's the probable cause statement, and then we'll watch the video. On April 11th, Brooklyn Center police officer Anthony Lucky and his field training officer, defendant Kimberly Ann Potter, conducted a traffic stop on a white Buick bearing Minnesota license plate 841 at UBY near 63rd Avenue North and Orchard Avenue North in Brooklyn Center, Hennepin County, Minnesota. Officer Lucky, he was lucky. He didn't shoot the guy. Identified the driver as Daunte Demetrius Wright. There's also an adult female passenger in the front passenger seat. Officer Lucky informed Mr. Wright that the officer stopped him because the vehicle had an air freshener hanging from the rear view mirror and the tabs were expired. Guys, don't hang stuff on your rear view mirror. Like, honestly,
what a lame thing.
Yeah. Now the expired tabs is justified though.
Yeah.
This is justified. But seriously, do not do the rear view mirror hang like, oh, you got your little dice. Women are especially culpable of this. Do not hang anything from your mirror. It is a recipe for a pullover. Officer Lucky returned to his squad car to conduct a record check for Mr. Wright, during which he learned that Mr. Wright had an outstanding arrest warrant for a gross misdemeanor weapons violation. As Officer Lucky ran these checks, Sergeant Michael Johnson arrived to assist the officers. Officer Lucky and defendant then reapproached the driver's side of the Buick to assist Mr. Wright on the warrant. Sergeant Johnson approached the passenger side of the vehicle. All right, so according to timestamp footage at 2:01:11 p.m., Officer Lucky asked Mr. Wright to step out of the vehicle. He opened the door at 2:01:22 and got out of the Buick at 2:01:30. At 2:01:31, Officer Lucky asked Mr. Wright to turn around and place his hands behind his back. Mr. Wright did so. Officer Lucky then began attempting to handcuff Mr. Wright at 2:01:36. So we're 25 seconds into this encounter for those keeping track, from the request to step out of the vehicle to the beginning to attempt to handcuff. Sergeant Johnson told Mr. Wright that he was under arrest, and at 2:01:39 p.m., defendant added that Mr. Wright had a warrant. At 2:01:43 p.m., Officer Lucky told Mr. Wright not to tense up. At that time, Officer Lucky and Mr. Wright were standing near the open driver's side door of the Buick. Defendant was standing behind and to the right of Officer Lucky. Defendant walked up to Mr. Wright at 2:01:45 p.m. and at 2:01:48 p.m. took a piece of paper from Mr. Wright's hand using her left hand. Defendant immediately transferred the paper to her right hand. This is all very weird.
It's a lot of detail, man.
Yeah, but they're laying out the exact body cam footage. At 2:01:49 p.m., Mr. Wright pulled away from Officer Lucky and got back into the driver's compartment of the Buick. He switched to a potential passive resisting here. Don't tense up. Might be a passive resist into an active resist, and that might be where this becomes really relevant. So he pulled away and got back into the driver's compartment of the Buick. Officer Lucky maintained a grip on Mr. Wright to keep physical control of him. I mean, I guess that's testimony. So as to pull Mr. Wright back out of the Buick, Sergeant Johnson, who was on the side of the vehicle, leaned inside the Buick through the passenger door. Defendant stated, "I'll tase ya." That was at 2:01:55 p.m. "I'll tase ya," and simultaneously moved the piece of paper she was holding from her right hand to her left hand. This is why that detail is there. Are you with me? Tasers, cops are supposed to draw with their non-dominant hand. In this case, her left hand would reach for a taser, but she moves a piece of paper that's in her dominant hand that she retrieved from the defendant to the other hand. So then when she goes to draw, she's going to use her dominant hand, and she's supposed to be being trained that the dominant hand draws the gun, non-dominant hand draws the taser.
Okay.
I think that's the case the state's going to make.
So it's trying to correct the idea of a mistake.
Yes.
Because she had to make this purposeful gesture, which, by the way, I don't believe for a second it was purposeful, whatever it was. It was muscle memory. So I'm not sure it really proves anything, but why not? It's one more fact that the jury can latch onto.
Yes. And that's the state's job here.
Yeah.
1 second later at 2:01:56 p.m., defendant's right hand holding her department issued Glock 9mm handgun came into view of her BWC. That's the body worn camera. Defendant pointed her handgun at Mr. Wright and tracked with Mr. Wright's movements as he and Officer Lucky continued moving. Defendant again announced, "I'll tase you," at 2:01:58 p.m. So 2 seconds after that, and continued pointing her handgun at Mr. Wright. At 2:02 exactly, so 4 seconds later, defendant said, "Taser, taser, taser." Sergeant Johnson and Officer Lucky both immediately began disengaging from Mr. Wright. 1 second later, defendant pulled the trigger and discharged her handgun one time, firing a single round of ammunition. The bullet entered the left side of Mr. Wright's chest and sequentially perforated the left 6th rib and 5th intercostal muscles, left lung, pericardium, heart, pericardium once again, right lung, and right 4th intercostal muscles. Damn.
That's a lot. That's a lot of things.
Right through all of the important things.
Both lungs and the heart. Yeah, that's going to be a problem.
Yeah, before partially exiting the right chest wall, perforating the skin and becoming lodged in the right side of Mr. Wright's chest. When she fired the handgun, defendant was standing outside the driver's side door and in close proximity to Officer Lucky. Defendant's handgun was just inches below Officer Lucky's arm. Here's the negligence that they're going to go for, I think. Or the recklessness, maybe. Pointing into the driver's compartment of the Buick in the direction of Mr. Wright, the passenger.
I don't see it. Why is there negligence in that particular aspect? I'm missing it.
Either negligence or recklessness in regards to Officer Lucky. Like she's defendant. This is just a weird detail to me to include unless they intend to point out that she put Officer Lucky in danger on making the shot.
Is she being charged with that? No, presumably not. So
I think
I mean, she's being charged with recklessness, but not in regards to
reckless use or handling of a firearm. So reckless handling or use of a firearm so as to endanger the safety of another with such force and violence that death or great bodily harm to any person was reasonably foreseeable.
I'm not sure if I buy that, but okay. If you're trying to use that particular aspect as your basis, I'm not buying that.
I hate to be on the side of Kim Potter here, but I think she's justified. I really do. So I think this entire prosecution is bogus and political. But I think in light of that, I think they're going to try and make a recklessness argument as to the safety of her fellow officers. That's my guess. I could be wrong on this, but we'll see. Yeah, and listen to how it goes from here. Defendant fired her handgun close to Officer Lucky's face, and then discharged cartridge casing from defendant's handgun appeared to strike Officer Lucky in the face as it was ejected. Yeah, they're going to go for that reckless use in regards to the other officer to try and, maybe to try and make an end run around the justifiable use. At 2:02:02, Mr. Wright says, he shot me. The Buick then traveled short distance down the street where it crashed into another vehicle. Defendant stated at 2:02:03, shit. And at 2:02:05, I just shot him. Another officer asked, you did? And defendant responded, yes. 2:02:09, defendant stated, I grabbed the wrong fucking gun, and repeated again, I shot him. 2:03:09, defendant stated, I'm going to go to prison. At 2:07:20, never say that, by the way.
Yeah, that's not great.
At 2:07:27, defendant stated, I killed a boy.
Also not great.
Yep, don't. Just shut your mouth. Other officers and paramedics responded. Medical personnel were unable to revive Mr. Wright. Mr. Wright was pronounced dead at the scene. 2:18 p.m. Assistant Hennepin County Medical Examiner Dr. Lauren Jackson later conducted an autopsy and determined the cause of Rice was gunshot wound and deemed it a homicide. SSA McGinnis later collected and reviewed the layout of the defendant's duty belt. SSA McGinnis observed that defendant's handgun was holstered on the right side of the belt, set in a straight draw position. Oh, okay. So she didn't reach crossbody. She reached like this, requiring defendant to use her left hand to draw her taser. The taser is yellow with a black grip, while the handgun is entirely black. Additionally, the texture of the defendant's handgun has a distinct grip from that on her taser. Defendant's taser is also equipped with a manual safety switch, which the operator must physically disengage before the taser can be discharged, and with a laser sighting feature, which causes a laser indicator to appear on the target when the taser is being aimed at after the safety is disengaged. Glock handgun is not equipped with such features. They're saying she should have known she was using her Glock and not her taser, which again, I think is disingenuous to the timeline, but and again, we'll look at it in a minute. During her 26 years as a police officer, defendant received a substantial amount of training, including training related to the use of force and specifically to the use of tasers and firearms. To everybody curious about that, she spent 25 years plus behind a desk. So she was actually new to the field on this one. But they're not going to have that as a defense if they can avoid it. Defendant completed annual recertification training courses on each of these weapons. These courses included training on how to draw, aim, and use each weapon correctly. Training material for these courses also includes notices alerting defendant to the possibility and risk of drawing a handgun instead of a taser. In the 6 months before this incident, defendant completed 2 taser-specific training courses. For example, on March 2nd, defendant attended a 4-hour training course pertaining to the taser. This course involved a classroom component which provided detailed and substantive information concerning the function, proper use, and safety concerns associated with using tasers, a practical component, and a written test. After this training, defendant was certified for use of the Taser X7. On defendant's certificate of completion, defendant provided her signature, acknowledging that she had read and understood the information and warnings provided by the manufacturer regarding the safe use of the taser. One of those warnings states, confusing a handgun with a CEW taser could result in death or serious injury. Learn the differences and avoid in the physical feel and holstering characteristics between your CEW and your handgun to help avoid confusion. Instructs officers to always follow your agency's guidance and training. In other prior taser trainings completed by the defendant, including another on November 5th, likewise signed paperwork acknowledging that she received, read, and understood identical warnings. So there we go. That's what we got. Any questions before we watch the video?
No.
Okay. Here is the video that we have. Whoops, I was clicking on the wrong screen. We have a warrant. We heard that. Couldn't hear the gunshot there.
No, maybe they took it out of the edit or something.
Yeah. Yeah, this one, I don't know if this one had a mature content warning or anything.
All right, so let's discuss use of deadly force. Does she have a right to deadly force in this situation? If so, why?
Okay, so that requires us to look up the Minnesota statute. Deadly force, peace officer. Authorized use of deadly force by peace officers. Here we go. This is the question. This is the question.
Well, it's a question.
Or
right?
yeah,
'Cause
it's not the question.
If she has the right to use deadly force, I think that substantially changes the analysis.
All right, so here we go. Deadly force. I think this is obviously deadly force, so we don't need to do that. Legislative intent. Should we skip that section for now?
Yep, I don't care about intent. That's fine.
Use of deadly force. Notwithstanding the provisions of 60906 or 609065, the use of deadly force by a peace officer in the line of duty is justified only if an objectively, so I think these are regular self-defense statutes.
Yeah, probably.
Only if an objectively reasonable officer would believe, based on the totality of the circumstances known to the officer at the time and without the benefit of hindsight, that such force is necessary to, 1, to protect the peace officer or another from death or great bodily harm, provided that the threat can be articulated with specificity by the law enforcement officer, is reasonably likely to occur absent action by the law enforcement officer, and must be addressed through the use of deadly force without unreasonable delay, or to effect the arrest or capture or prevent the escape of a person whom the peace officer knows or has reasonable grounds to believe has committed or attempted to commit a felony, and the officer reasonably believes that the person will cause death or great bodily harm to another person under the threat criteria in clause 1, items 1 to 3, unless immediately apprehended.
Okay. So my first thought is that neither of these sections apply. So let me deal with the second one first. There's a famous Supreme Court case called Tennessee v. Garner, which deals with a police officer using deadly force merely for the purposes of arresting someone. And the Supreme Court said, no, not so much with that plan. You can't use deadly force merely for the purpose of facilitating an arrest. Now, this statute says you need that and that they're posing a threat that's imminent, an imminent threat. So I don't think there's sufficient information based on what I know to conclude this guy is posing an imminent threat to anybody at that time, even if he gets in his car and speeds away. While he could be posing a threat, any threat would be speculative. There's not enough information to conclude that there is a true threat in place. So I don't think B applies. And as to A, I don't think there's any particular threat to the officers in that moment either. So I don't particularly see use of deadly force, but feel free to correct me if you disagree.
The place that I disagree is that getting into a car and driving is a threat of deadly force to officers in proximity. That's the issue.
If there were officers that were like in front of the car or something, then yes, but I don't think merely by being in proximity, I'd agree.
I don't know. The dragging an officer is serious bodily harm. So you got an officer who's got his hand in the vehicle, holding on to the guy. He tries to drive away. Is that serious bodily harm? I think so. I mean, I don't necessarily agree with the conclusion, but I think that conclusion has been reached by courts.
Maybe. I think under this fact pattern, it's a little bit too speculative for my taste, but that's just my personal judgment on that.
Yeah. One thing I want to get to is he did not have a felony warrant. However, the fleeing the officer lawfully executing a warrant is a felony, I believe, under Minnesota law. So
that's fine.
Just in case the chat was curious about that, I just wanted to point that out. So the question is these 3 things. This is what comes into question. Is there to protect the peace officer or another from death or great bodily harm, provided that it can be articulated with specificity, reasonably likely to occur absent action by the law enforcement officer, and must be addressed through the use of deadly force without unreasonable delay. That's what she's got to prove on the justification. Now, I think so. I don't have the case law pulled up on this one. I might be covering this on the nighttime shows leading up to the trial that starts on Tuesday, because I want to get into some of the motions that have been made and see what if they have some case law cited that they're arguing. I'm not abundantly familiar. My gut tells me that we're going to find a case in Minnesota where the use of deadly force, or the finding that using a vehicle with officers in close proximity amounts to deadly force, either justifying a use of force by the peace officer or by justifying a criminal charge of some sort of attempted manslaughter or attempted homicide or something like that using a vehicle. That's my gut on it.
No, of course, my failure to find self-defense doesn't mean guilt, because I still have to find liability under the underlying statute,
Right.
which I'm not sold on.
Should we
Because
pull
I
up the
don't-
underlying statute real quick?
Yeah, sure. I mean, those would be the manslaughters, right? So it would be a self-defense claim to manslaughter. And I'm not sure about the liability under the statute. So I don't really need to, strictly speaking, reach the issue of self-defense or defense of others, because if I don't get the statute, then it doesn't matter.
Right. Let's see. Here we go. 609.20 is the statute here. 609.20. Manslaughter in the first degree is our first statute. Whoever does any of the following is guilty of manslaughter in the first degree. Intentionally causes the death of another person in the heat of passion provoked
No.
by words or acts. No. Violates 609.224 and causes the death of another, or causes the death of another in committing or attempting to commit misdemeanor or gross misdemeanor with such force and violence that the death of great bodily harm by any person was reasonably foreseeable. Let's see what this is. That's a 5th degree assault. Commits an act with intent to cause fear in another, immediate bodily harm or death. Intentionally inflicts or attempts to inflict bodily harm on another.
Okay.
So let's see, maybe on that one. Intentionally cause the death of another person because the actor is coerced by threats made by someone other than the actor. No, I don't think there's coercion here. Approximately cause the death of another without intending to cause death by directly, indirectly, or unlawfully selling, giving away, bartering, delivering. And then cause the death of another and committing or attempting to commit a violation of malicious punishment of a child. And murder in the first, second, or third degree is not committed thereby.
I'm not sold.
That's not there.
Yeah, I'm not sold.
Yeah, so this would be the one, I think. Let me pull up the charging document again. It's with reference 609.11.5, which is going to be, I think that's the penalty.
Hello, everyone. Nick has gone away. I think he's dropped out. I think his connection has dropped. Okay, well, that's fine. No, Nick's back. Yay. I was about to have to ad-lib the show.
I clicked back on the wrong window. Sorry. Here we go. So 601.115 is just that's pre-sentence investigation. Is that? Oh, I don't have it pulled up here. Let me show that again. Sorry. So 115A is yeah. Okay, this is just about sentencing.
No, I don't know that right now.
Okay. So then so 609.205 is the next one, second degree manslaughter. So death of another by any of the following means: culpable negligence, whereby they create an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. Or by shooting another with a firearm or other dangerous weapon as a result of negligent believing the other to be a deer or other animal.
No.
Spring gun? No.
No.
Intentionally permitting an animal to have violent. So this is your pit bull argument. Committing or attempting to commit negligent endangerment of a child.
No.
So the question is this: did she create an unreasonable risk and take chances of causing death or great bodily harm to another?
Consciously take chance of causing death or great bodily harm, mind you.
Yeah,
And was she doing it consciously?
I don't think so.
I don't think so either. I think, yeah, I don't really personally see the self-defense, but I don't see the liability for the underlying statute either. So I
let's
think my
see.
my tentative conclusion would be not guilty.
So while committing the misdemeanor offense of reckless handling or use of a firearm so as to endanger the safety of another. This isn't in the statute,
No, we just read it.
but that's what they're trying to argue here. So let me check that one more time. So it's 609.20.2. 02 is the section that they're going with. So it is this one. So this is assault.
Yeah,
So
this
they're
is
saying
assault.
it's 5th degree assault.
I don't buy it because because I mean there was assault for sure, but if you go back to firearm, that's an enhancement charge, right?
Yeah, it's
The
enhancement.
firearm section, that's an enhancement. Yeah.
So this commits an act with intent to cause fear in of another of immediately bodily harm or death,
No.
or intentionally inflicts. She doesn't meet any of the intent requisite for this.
Yeah. So you don't have assault in the 5th degree, and even if you did, I think you have problems on the underlying statute for other reasons too.
Well, now, okay, let me posit the state's argument. She was actually intending immediate bodily harm with the taser. Because she was trying to, it's not serious bodily harm, it's any bodily harm. That's why there's a 5th degree, it's a misdemeanor assault, right?
Okay. I stand corrected. I misread it. Your reading is correct. So there is assault in the 5th degree. I stand corrected.
That's what the state does. So the act with intent to cause fear in another of immediate bodily harm or death. So then I think we get to use of force questions on that one. I think the second charge is no go, right? Count 2 seems weak. The 2nd degree manslaughter. But the 1st degree, maybe they get the misdemeanor charge on the intent to cause bodily harm with the taser. But then the question is she justified in using force or deadly? If she's justified in using deadly force, then it's fine. If she's justified in using force, that
not deadly force.
Well, that would obviate the assault, right? If she's justified, because like a mistake, her using the gun is not intentional.
Right. So she would be justified in using the but does it obviate the assault though? Because I don't know. That's a good question. I don't know.
That's really tough. That's a tough call, is because if she's justified in using some force, which is the misdemeanor, and presumably the theory the state's going to use, I think there's no argument on earth that she's justified in using the taser in that moment.
Right.
So the state is going to argue that despite her justified use of the taser, her intent to use the taser transfers to intent to use the gun sufficient to get rid of her self-defense claim or her use of force claim. That's a stretch for me.
Yeah, that's a stretch for me too. And the defense basically is mistake of fact, right?
Yeah.
I thought I was reaching for my taser.
Right. And I mean, there's no indication to the contrary that we have.
Yeah.
I mean, there could be some recording or text message of her saying, I'm going to say taser, but I'm totally going to plug this guy. Like
especially on a proof beyond a reasonable doubt standard. I think not guilty is probably the better call, all things being considered, although I'd be willing to have my mind changed. But on an initial read, again, I think not guilty is probably the better decision.
Yeah.
But I'd go into this, even with as much knowledge as I know, I'd go into this with a pretty open mind at this point.
I think they have a possibly compelling civil case where the standard of proof is not high.
Yeah.
Wrongful death against the city, negligent training, negligent supervision, these sort of things. Certainly. But on criminal, I'm not there. I'm not with the state of Minnesota on this one. So we'll see though, that trial, again, starts Tuesday. I will be watching it. We'll be starting at, I believe, 9 a.m. Central Time on that.
I mean, they're just going to go into her training in depth. Basically, the prosecution's case, they're going to call her taser instructor. They're going to call other people about uses of tasers and how they discuss it 18 different ways about how, not to confuse the two, never use this hand, always how they feel different, and how she was certified and all the rest of it, how she should have known from the feel or the fact she didn't have to disengage and all the rest of it.
Yeah.
Defense would probably just be like, yeah, it was all muscle memory, so she wasn't thinking consciously, which
Right.
I think is probably true. But they're just they're just gonna try to go that it was basically beaten into her to not make this mistake, so she shouldn't have that memory confusion. So
and won't the defense be not well enough? Obviously, the training was deficient.
that could be an option. That could be an option.
I think there's lots of cases where officers pull the wrong item off their belt in the heat of things, and maybe they'll bring in I'm sure that would be the trick, right? You got to bring in an expert, maybe a trainer, and say why, because hypothetically you bring in a trainer, right? I've been training law enforcement officers for 35 years. Bring this guy in, say, why do you train law enforcement officers? Well, because when you're out there on the field, you want to get as much muscle memory as possible. You want to get it to a point where they're reflexively doing this stuff, because you can't always consciously think about it. So it'd be hard to intentionally do something like this, right? And that's what you're training against. Isn't that correct? Yeah. That's the type of questioning you'd want to go into with your expert and say, why do they do so much training? And especially with the state's expert who they're going to bring. Yeah, because that's when you get to cross-examine them. And, that's kind of the theory I'd be going with on that particular expert, or bringing an expert in that way. But
it'd be interesting if you could extract from the defense experts on cross, despite all the training in the world, do people ever make mistakes, or how frequently maybe there are studies to that effect. It's like, are you familiar with this study? Are you familiar with this study? Because you're such a use of force expert that shows that X percentage of the time, or Y situations, or whatever. So if you can extract that from them, that would be good. So the defense, I think the defense has chances. I think the prosecution has chances. I lean not guilty, but it's not a sold conclusion in my mind.
Yeah. I think this one hinges on this one's going to be heavily on the testimony. I think, I don't think it's weirdly not as fact specific as the other one, right? As the Texas shooting.
Well, that one, is a factual nightmare, because we have to keep going to different frames, different parts of time, and asking different questions at different frames of reference, which we don't quite have that problem here. So thank God for that.
So people want me to do a poll on this one. Okay. Chad Reed shooting results, justified 31%, not justified 30%, not sure 39%. So
basically it's an even split. That's good.
Really, really close. I think that's the right answer on that one. Like I said, I lean justified on this one, but I am willing to be sold the other way. Okay, so we'll do a poll on Kim Potter. I got to do manslaughter 1. Guilty. Manslaughter 2, guilty. Then we're going to do both charges, guilty. And then we're going to do not guilty on the third one. Oops, can't spell. Not guilty. All right. To the chat. This is your opportunity to weigh in on the Kim Potter thing. These polls are fun. I think people like polls. That's why they like me. I'm very Polish.
There you go.
Okay. Nick, are you going to cover the shooting of Garrett Foster trial? I have no idea what the shooting of Garrett Foster is or when the trial is, but maybe. Okay. So that being said, let's I'm going to pivot over to super chats now. There's a bunch of those. Were you game for hanging around?
I'll let you take care of those though. Okay.
Yeah, man. Thanks for hanging out. This is a lot of fun, and going through this is great. So,
all right. Good luck with the super chat stuff. Talk to you later.
See you, buddy. Peace. All right, chat. It's just you and me and my bump for the headphones. I got to get some headphones that don't do the bump. We're going to figure that out really soon. Read reckless use of a firearm. It's not actually listed in the statute. Let me see. Because they didn't cite the reckless use of a firearm at all. Get some hair, boom, roasted. Oh, yeah, they didn't cite that in the Minnesota case here, the reckless use of a firearm. Oh my goodness. Is there even? Let me see if there's even a. No, there isn't even a statute for reckless use of a firearm in the penal code for Minnesota law. So, yeah, there's nothing specific. It's just that 5th degree assault. Okay. Like I said, we're going to do the super chats here, and then we'll wrap up the show. There will be another show tonight on some subjects. But Brendan Andrews says, what's my quick thoughts on Chad Reed? My quick thoughts on Chad Reed are, one, it's a very, very complicated and close case. There's a lot to go through, but I think ultimately he's justified. That's mine. You guys were wrong on the interpretation of the term habitation within Texas? No. No, I don't think so. I'll show it to you. I don't know why you think we're wrong on this, but here you go. Real quick. Habitation means a structure or vehicle that is adapted for the overnight accommodation of persons and includes each separately secured or occupied portion of the structure or vehicle. Okay, so that'd be other things. Each structure appurtenant to or connected with the structure or vehicle. That's a porch. That's a porch. That's a structure that is constructed and it's attached to. It is an appurtenance. So I'm not sold on being wrong on that interpretation. Rose Bebe says, in case you go to YouTube jail for this will help you with your bail. Oh, thank you. Not quite all here says legal pun plus descriptive title for the show, impaneled. Brandon Lesko says only one could go shot for shot with the video. I'm gonna hold off on going shot for shot, especially in the daytime, because after this I have to go get some things. CS says this is the fault of lawyers and family court. Kids become property in a divorce. Ace Brain is next. Oh, and one more thing on the Chad Reed shooting. Just because it's justified does not mean that I believe that Chad Reed deserved to die. I do not. I do not think that at all. It's just how it ends up working out, unfortunately. We're not talking about the propriety of what happened. We're talking about the criminal liability. Ace Brain says the deceased went from Chad Reed to Chad Red, past tense. I'll see myself out now. Oh my God. Juan Sex Fiddy Juan says, does the type of ammo used matter in a self-defense claim? It shouldn't. And what's the threshold on how many rounds you can use and still claim self-defense? As long as it's reasonable. There's no threshold. If it requires 30 rounds to put someone down, then that's what it requires. Not My Regret says, based on what happened, wouldn't Kyle firing a warning shot be the use of deadly force? From what I understand, are warning shots not allowed? Warning shots are deadly force. Whether or not they're allowed is always a question of justification. I think, in my analysis, that he was justified in using the warning shot. You just shouldn't use a warning shot because it is equivalent of shooting someone. Then you get into questions of, is it reckless because you're going to have to argue that you didn't intend to kill them, but you did discharge your weapon, which is reckless. indifference. So, I mean, there's a lot there. And he may have a reckless discharge. He may have that. But I think ultimately it's going to come down to this guy entered into his habitation and assaulted him. And then continued the assault by throwing him out of his habitation. Yeah. That's where I go with it. I'm happy to be corrected. We'll see. Maybe we'll see, but it's probably going to be a while. Brett Smith says, does he grab the gun before he's pushed off the porch? Yes. If so, could that help the self-defense claim? Yes. The distance isn't that far and it happens very quickly. Yeah, the guy grabs a gun twice, or he manipulates the gun one time, maybe not grabbing it. The second time, he clearly grabs it as part of the throw. So, Jamie Moodley says, chess is my wealth. Hungry Ewok says, a bar of lawyers. Werewolf says, warning shots should be illegal. That escalated the situation intentionally. This feels prepared. Again, I don't know how you escalate the situation beyond the guy saying, I'm going to grab your gun and take it from you and use it on you while also in physical contact. I don't know. I don't know. Hold on. And let's not forget that he says that in this context, you better use it or I'm going to do that, right? Like it is clearly communicated as a threat. If you don't kill me, I will kill you. So Jason says, is it true that mag dumping makes it look better, like you panicked and just emptied the gun? Depends on the size of the mag, right? If you have a 100-round drum magazine, probably not. Chain Breaking Sage says, there's no way a court in Texas is going to see getting your gun because there's a belligerent individual on your property as provocative. Thank you. That's one thing I very much disagreed with Joe's statements on. It's clearly necessary, judging from the size difference. He flung him like a rag doll. Yeah, I just think you're in Texas, man. Someone saying, get off my land, get off my property. Guy not leaving. Like, all right, I'll go get a gun. If you're not going to leave, like, you need to know. And the idea that getting the gun is somehow provoking a person to come towards you, didn't buy that argument. And I don't buy the argument that the warning shot is provocative for someone to attack you either. Again, my general policy is to advise people not to fire a warning shot in any circumstance. However, the reasonableness of a warning shot, or the intended purpose of a warning shot, typically is to deter someone from attacking you, not to bring them closer. So when you're talking about whether this warning shot fulfills provocation, remember that provocation jury instructions, as Legal Bites read, required the intent that the act would provoke an attack for the pretextual purpose of shooting the person in self-defense. I don't think it's going to work. I don't think that's going to work at all. Andrew Hicks says, really? So like the day streaming, can't Joe and yourself are a powerhouse, being utility surveyor and working Thanksgiving. One more week in New York City, then I can be back home in the Adirondacks. Want to meet Joe before I go. Well, Joe's technically in New Jersey, so you gotta reach out to him some way. Fernabelle 13 says, as a kid in Texas, my friends from up north noticed that every fight would begin with what they coined Texas nipple fucking. Rubbing sounds better. Thank you for adding to my lexicon. It is, that's the way it goes, man. It's a weird thing. Brominated vegetable oil says, the argument of the gun being pulled for self-defense is lost by also throwing his person into his assailant. Had he taken a posture at the doorway and told him to get away, the victim step into him. Different story. Nah, I disagree. Again, when that guy comes at you, what do you have no duty to retreat. I don't think that's the thing. Big Red Bear says, shoots him at a distance where the man was no longer moving towards him. It's a bad shoot, my dude. Killed an unarmed man who was no longer moving towards him and flung him away. In fact, this looks like murder to me. I think people can come to that conclusion. I think under Texas law, though, I don't think it's gonna stick. The guy was still on the property. He removed someone from his habitat. I don't think it's going to stick. I don't think it's going to stick. The guy was still on the property. He removed someone from his habitat. I don't think it's going to stick. The guy was still on the property. He removed someone from his habitat. I don't think it's going to stick. The guy was still on the property. He removed someone from his habitat. The way I read the law, I don't think so. Gonfall says, this angry little man is getting mad because his wife is mad is just ridiculous. I think it was wrong to shoot him, but by law, he was justified. The stepdad is trash. He stripped every right from that child because of the anger he can't control. Again, very reasonable conclusion there. Should the guy have gone and gotten a gun? I don't think it helped. I don't think it helped. I don't think that the guy was likely to attack, but I don't think it amounts to legal provocation. So again, there's a distinction between what we think should happen versus what legal requirements there are. Scarlock says, hippity bippity dippity boppity, you weren't fast enough in getting off my property. Anthony Smith says, but the shooting happened after Kyle left his habitation. He did not leave. He was removed. He shot Chad while Chad was standing still. If Chad were to go after Kyle at this point, he would have to leave the habitation. Yep, he would have. But you can't throw someone off of their property or out of their building. You can't throw someone out of their, again, remember that the predicate act is requiring physical force to remove someone from the safety of their habitation, their castle, their sanctuary, where they can remove themselves from the world. You have to go into that, grab them, and remove them from it. Once you do that, don't do that to me. That's what I'm saying. Don't do that to me. Don't come into my house and grab me and throw me out and expect things to go well for you. C4 Own says, I'm a little proud of myself. I'm no lawyer, but last night Nick's reasoning about burglary was the same line of reasoning I had in our discussion in Joe's Discord. There you go. There you go. Werewolf says, if he is scheduled to be there by a court agreement, can he be trespassing? Yes. Is that are justified in an explanation of protecting property? You could still be trespassing even if you have a court agreement. If they tell you to leave, you have to leave. You do not get to use physical force to enforce your court order. You have to get the court to enforce the court order, which is shit. To be clear, the family court is garbage, and the fact that that their court orders mean nothing, and that you have to then employ the court again or beg a police officer or whatever you have to do. It sucks. It does. Trust me. Don't get involved in that. But that's the way it goes. Wasn't he waiting for the police too? Yep. And he should have waited off the property. If he's waiting for police, you have to leave the police cannot force someone to be on your property without your consent. They can't do that. And they won't. They won't get involved in that. The police have to have a warrant. The police can't even stay on your property without your consent. They need a warrant or an exigent circumstance to do so. So again, if this guy called the police and they're supposed to be coming to help him affect the transfer of the child, he has to wait off the property if they ask. And then the police with a valid warrant or a court order can then enter the property and can give permission to the person to enter the property to retrieve the child. That's the way you'd have to do it. But you cannot stay on the property if the property owner tells you to leave. You are then a criminal at that point. SGS says, or probable cause. No, the probable cause is never sufficient. You have to have probable cause and a warrant. If you have a warrant, you have probable cause, or you have to have probable cause and a valid exception to the warrant requirement. Exigent circumstances, hot pursuit, plain view, these types of things. But you have to have a valid exception to the warrant requirement. Patrick L says, I am biased against legal bites due to her Valley Girl-esque use of the word like. There you go. Next. We have Rylan Davis says, isn't it hard for her to argue she was justified in deadly force when she didn't fear enough to intentionally use it? That might be a complicating factor. It might be a complicating factor, but if you're justified to use deadly force, using lesser than deadly force doesn't mean that you automatically lose your right to use deadly force. If you're justified, you're justified. But it could complicate whether the subjective reasonableness existed. So we'll see. By the letter of the law, is she not guilty of killing through negligence? I don't know if she's guilty of killing through negligence on that one. I mean, that's one of the arguments, but based on reading the statute for second-degree manslaughter, I don't think they meet it. Not Heisenbear says, my friend, a sheriff deputy, told me he has pulled his service weapon instead of his taser in the line of duty. He noticed the issue and switched. Yeah. Yeah, I think it probably happens with some level of regularity, which is, again, why they train against it. Peter Watkins says, wife filed for divorce. So I'm staring down the barrel of the family court myself. Have this money. You deserve it more than my B of a wife. Shit, buddy. Good luck. Good luck. I always hate to hear about divorce. It makes me unreasonably sadder than it should, but it's a fact a lot of people have to deal with, and I don't wish it on anybody. So very sorry to hear that. Lewis Martin says, I believe Chad would have been justified to shoot if he had a concealed carry as soon as he came out of the house with the AR. Changed my mind. No. If you have a concealed carry and some guy comes out of his own property, but you're on his property, he comes out with a gun, you pull a gun and shoot him. Nope. No. Do not get that thought in your mind. You do not want to be shooting a man on his own property. Nope. You're going to lose that case most times. Holy Hand Grenade says, tasers are not less than lethal. They are less lethal. How can you get that wrong? Did I even say less lethal versus less than lethal? They're not considered deadly force in most states. There. That's what I'm talking about. So, calm down. Sublime and Slime says, sorry for your problems with fascist YouTube brown shirts. Read that one. Rick Nikita says, literal Looney Tunes attack the Capitol. Z Michael Gelke, or literal Looney Tunes, attacked the Capitol in quotes. Z Michael Gelke says, you can't bring publicity to the political prisoners even by repeating the claims of the state. Kimberly Campbell says, what I don't understand is why Shaman Guy got 4 years for trespassing, because he is being made an example of. That's why. That is why. What if you defend yourself against someone who is in their on their property, but you are not on their property? Again, you have to have the justification. Like, you have to be able to articulate how they were threatening your life, which some guy carrying a gun on his property is not going to do. They would have to threaten you or something like that. Do we even know if he lived there or just a boyfriend? I believe it's his place. I don't know, but if he is, I guess that could be a complicating factor. Maybe. All right, next. Steven says, hey, Uncivil, remember that time not even a week ago when you said Legal Eagle is a good lawyer, having never, ever even seen him in court? Slobla knob. Damn. Lofty Tranny says, has Uncivil Law thought of transitioning like me to get some of that sweet, sweet tranny privilege? The Buzz CJC says, I want to thank Raggets for allowing Legal Eagle onto his show today. Jeez. Poor Kurt. Dova Bear says, 3 assertions. Exiting home to confront while brandishing is provocation. I think we talked about that. Warning shots equals use of lethal force. Interfering with child custody equals a felony. Yeah, not really. On that third one, we didn't really talk about this too much, but interfering with child custody, I don't think that's going to apply in this case. But if you say it's a felony in Texas, I'd be curious of the code. Let's see if we can find it. Texas statute interfering with child custody. Under Texas Penal Code 2503, a person interferes with child custody when he or she takes or keeps a child under age 18 when they know it violates the terms of a judgment, a court order, or temporary order. A non-custodial parent commits interference with child custody if, with the intent to interfere with the lawful custody of a child younger than 18 years, he or she knowingly entices or persuades a child to leave the custody of the custodial parent, guardian, or whatever. Let's here we go. Yeah, I don't think this statute is going to apply in the way that you might be thinking. We'll take a quick peek. If the person takes or retains a child younger than 18 years of age, when the person knows that the person's taking or retention violates the express terms of a judgment or order, including a temporary order of a court disposing with the child's custody, when the person has not been awarded custody of the child, knows that a suit for divorce or application for habeas corpus has been filed, and takes the child out of the geographic area of the counties composing the judicial district, outside of the United States, blah, blah, non-custodial parent. Let's see, the non-custodial parent knowingly entices or persuades the child to leave the custody of the custodial parent. I think the custodial parent in this case is probably the mom, just in general. It is defense to the prosecution under subsection A2 that the actor return the child to the geographic area of the counties composing the judicial district if the district court, blah, 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 is a statutory county court within 3 days after the commission. Affirmative defense under A3, which is outside the United States. So the question is basically, is this. Look, violating a custody agreement by a matter of minutes or even hours is not going to be a felony charge in Texas. It's just not going to be. So, Bogey 34 says, "Hey guys, Kaiser case. If a minor trafficked can't be held liable for any felonies conducted while being trafficked, how is she getting out of prison?" I don't know. I don't know the it has to be directly tied to the trafficking as well as being while being trafficked. New Age Cuck says, "What did I miss?" And also, I think she was getting out of jail, not prison. I got to read more on that case. Andrew Starr says, "An acquittal of lawyers in honor of Kyle." HBG313 says, "Does Legal Bites not understand sarcasm?" Goovyfoot says, "Law splaining." Brian Lindauer says, "What do you mean, you lights?" Saturn Tube says, "Did anyone else mistake on civil law for Ethan Ralph? I hope not." Orthelio says, "What happens to Binger and Krause now career-wise?" Nothing. They'll keep going on forever. They did exactly what the state prosecution offices want. I see you watching you daily. I see you. Eddie Oliver says, Carrot's attorney said all Texans may lawfully brandish a firearm to protect themselves, their property, and their business. Is that accurate? Is that legally accurate? No. Maybe. I don't know. That's an interesting distinction. I don't think that's good legal advice, but that's him advocating for his client. And that's not him saying it before a court. So Really Now says that's what happens when you and 10 other folk jump on a 130,000 stream and destroy MSM ratings. Keep up the good fight on civil. Mark O and W says, Kerp, was the flag video your one about the folks that killed a cop with a fire extinguisher? Swade's Lounge says, Salty deletes all his streams on YouTube immediately after they end. Tells everyone to go watch them on Odyssey and Rumble. Ken Langley says, Legal Bites sweater is greater than Binger's lapel pin. Slaglass says, panel consists of Uncivil Glowy, Legal Bay, and Oy Vey. Nope. Yep. Says the YouTube team is a call center in India. You're never going to get anything out of them. Really Now says, Legal Bites puts her toenail up for sale in her merch store. Karaza says, thank you for the awesome content. You and the Invoice have inspired me to go back to law school. I'm 40 and the major breadwinner for my family. Any tips for making it through without offing myself? Do the work. Just do the work. It's fine. I enjoyed law school. It was fun times. It was a lot of work and it was a big imposition on my family life, but it was still fun. Mark Watts says a warning shot discredits any claim that deadly force was immediately necessary. My legal understanding as a layman is that it's never a good idea. Your legal understanding is correct, but the question is, did he have justification for the warning shot as deadly force? And then second, did he have justification after he was thrown off his property and fires again? I think that's one of the potential questions. Bear Business One says Joe has the prosecution video. Ricada has the defense video. 200 Watt Studio says wide open spaces refers to the guy's chest nick. Elvin Sin says let it be known and goodbye Earl. The Dixie Chicks confessed to conspiracy to commit murder. Z Michael Gelke says murder and the commencement of kidnapping. Both him and her need to go down for felony murder. It's not kidnapping to be late on turning over a kid. It can't be. It would be so impractical to charge people with kidnapping. I mean, you're talking days have to go by. And even then, they're not going to charge him with kidnapping. It's just not going to work out that way. Woods Bear, welcome to paralegal status. Chad Reed says nipple rubbing is not a crime. Matthew Smith says if you want morbid humor, join the military. Steven says the dude with shotgun can get off, but he'll go broke well before. Hope he's ready to sell that house behind him. Sin City says he may have been justified, but to me, he wanted that man dead. Could be. Not going to argue against that. Yard Hatch says, did he say, I take it from you and use it before grabbing the barrel of the gun? Yes. Dwayne Kate says the perception war begins. There is no suspense here. He will be no build. Whalier says, I didn't want to do any of this. It's a very interesting statement. Does that imply that there was some sort of plan for confrontation? I think it just means I didn't want to shoot a guy. Andrew Starr says, you don't get to stay on someone's property after being asked to leave, assault the owner, try and take their gun and be the victim. See, this is a charged case. Chain Breaking Sage says safe. Beatrix Kiddo says burglary. This man's son was being held in the house. We have no evidence that he was currently. He said, I don't have your son. Wife said the son's not here. And even if the kid was in the house, and again, it sucks, but you don't get to enter the property without permission. You just can't. Because otherwise you could always have a son in the house, right? Oh, I think my son's in there. I can just justify going in. Doesn't work out. Jonathan Duger says, dude shouldn't have showed up starting crap. Dude was obviously Rosenbombing the shooter. Chain Breaking Sage says he assaulted the man on his own property. Safe. Shinobi Assault says, would a court order or visitor pickup of son give him some rights to be on the property until he's asked to leave? Again, if they violate a court order, you have to go to the court and ask for a contempt charge. That's how that works out. Benjamin Smith says, Nick, could use shillage for Blue Crucible, book 1 of the Blue Cavalry series in the post-apocalyptic Fallen World universe. Only 99 cents this weekend on Amazon. Book 2 also available. Justice lives even when society dies. There you go, guys. You can check out Benjamin Smith's book, Blue Crucible, book 1 on Amazon. $1. $1 to get it. Check that out if that's what you're into. And good luck, Benjamin Smith. I hope things go well for you. Happy Gillis says, would saying he was defending his family do anything? Because the green shirt guy put himself between the guy with the gun and his family. I'm not sure who's defending the family. Kyle, the guy with the gun, or Chad, the green shirt. I don't think it matters here either way. I'm just curious what you're thinking. Kyle Harold says, but if he has a court order to be there for his kid, he has a legal right and would be contempt on the order to make him leave without his kid. It's only contempt after a judge finds contempt. It is not contempt earlier than that. You have to take them through it. You can't. I have a legal right to be here until you're asked to leave. Then you don't. Just a guy making his way says Chapter 9 of the Texas Penal Code has your answers. It is a CT in progress. What's a CT? Criminal trespass, I think is what you're saying. Maybe not. Knit Girl 113 says, weren't they having an affair and the deceased was also threatening to expose the affair to the man's wife, who is a judge, to have accurate facts? I don't know. Morgan H says, would the first shot into the porch be considered provocation? Was that a negligent discharge or a warning shot? It may be both of those things. I don't think it's provocation, personally. Gerald Armstrong says, just like the Arbery case, the ex and her boyfriend violated the court order for the child, which is a felony. This is felony murder. Again, you're not going to get a felony charge for being a little bit late on a pickup. Otherwise, there would be felonies every day, constantly, right? Parents in traffic, whatever. Kids attends an activity. Kid just doesn't come home from school. Kids at a friend's house. Yeah, that's not a road we want to go down. Chain Breaking Sage says, he also threatened to take his gun and use it if he didn't. Andrew Storer says, if this isn't defense, then we have no Second Amendment or private property rights. Teal assaulted Black twice, reached for the gun twice after being asked to leave. Ryan Burkebile says, besides Google, where can we find our state's castle laws? Well, DuckDuckGo would work. The Rowdy Pope says, I believe he demonstrated you can clearly resolve parenting time issues without the court. Goose says the kid is going to be so broken after this. That is a really awful section of this. Andrew Starr says, false. Yes, he did after he was asked to leave. He clearly stepped towards Black and threatened him and followed him to the door. He does do that. Wolfgang Puck 3102 says, I think section 9.04 threats of force, 9.41 and 9.42 would also be relevant in addition to 9.31, 9.32, but defer to you guys. We read all those, I believe. I don't know if the threats of force is super relevant because it just said that threats of force alone are not sufficient. Real Hydro PX says, I read that this has gone to a grand jury. Is this true? I don't know. I feel like I saw a mugshot of Kyle Kareth today. See, Michael Gelke says they kidnapped his son, took him elsewhere rather than turn him over, and then murdered him in the commission, felony murder for him and the ex-wife. Again, you can have that opinion. There's no way they're going to get to that conclusion. Unless I'm missing a fact and the son has been held over for a significant amount of time, which is possible, but I don't think so. Selick S says, it bothers me that when he shot the guy, there was space created between them and the guy wasn't moving towards him. Wouldn't the reasonable thing to do to be to give him an ultimatum to leave right then with the gun aimed at him? Aiming a gun at someone's a provocative act. So I don't know if that's the best move. He had the gun clearly out and gave him an ultimatum to leave multiple times. And instead of following that ultimatum, the guy went towards him. He charged into his property. I don't think so. I don't think that's going to fly in a criminal defense standpoint. David A. Hamilton says, if he believes the son is somewhere else, he doesn't need to be there. He provoked the entire incident. If this is true, it's an interesting point. If you think the son is somewhere else, like at your mom's house, because that's probably where he is, why are you still there? What are you doing? Especially when you've been asked to leave. Ryland Davis says, are you not allowed to tell someone to leave your property while holding a gun? You are. He didn't point it at him until the guy tried to take it. You are allowed to do that. It's not legal advice, but typically. 200-Watt Studio says, you hear nipple rub, a binger gets their wings. Terry Bell says, we have more rights to self-defense here in Texas. However, it still has to be reasonable. This was murder. Definitely not clean self-defense. Really Now says, I'm all for castle doctrine, but when you violate a court order, then you escalate it without any physical threat. Sorry, you just murdered someone. We don't know that they actually violated the court order, right? That's not adjudicated. And you could not arrest them for violation of that court order without going to court to adjudicate the violation of the court order. Trust me, I've tried. I've tried to do that. People flagrantly violate court orders all the time in civil matters. That does not give you permission to, those don't automatically resolve. They're not self-authenticating or self-resolving. You have to go to a court to get that resolved. AM says shooting wasn't a split-second decision. He took a second to position himself and then shoot twice. Saw him standing still before shooting. Yep, he did. And that may be what gets him. Tankrat says, before Kyle went into his home and retrieved and load his gun, he told Chad to get off his property. Chad says something to Kyle, then Kyle went inside. Beth Woodfin, thank you for the donation. Greg Ray says that Binger approved warning shot at the ground seems like provocation to me. He didn't try to grab the gun until he fires the gun recklessly at his feet. That's not true. Actually, we saw that he does manipulate the gun prior to the warning shot. PFAB says, have you guys heard of Legal Eagle? He's actually a lawyer in real life. You should ask him about this case. Oh, God. Rhino says, it doesn't matter if the shooting is justifiable self-defense or not. The shooter has political and legal connections, so he's not going to be convicted, not in Texas, with this much ambiguity. I think that's reasonable. Real Hydro PX says, guys, hope we all learn from this. Never get with a woman who has children who are still young. Never get with a woman who has been married before. Just a guy making his way says you can use force to stop someone from trespassing on your property. Bringing the gun out is legal and is not provoking. AM says the mother should be charged with kidnapping if they refuse to give the child at legally required time. Again, you don't actually, if they can't produce the child because they're not physically there, because they're just late, that's not a refusal to produce the child. That's inability, and that's a different thing. Should they have planned better? Maybe. Who knows what circumstance would keep the kid away from the house, right? We don't actually know that. Was it even intentional that the kid wasn't there? How old is the kid? I don't know. But again, merely keeping a child past the parenting time handoff is not going to be a felony. Like, you're talking about putting someone in prison for over a year because they kept a child for an hour past the drop-off time. No way does that fly. Moms and dads across this country would be filling the prisons immediately. So it's just not going to happen, right? Look at how long it took Michael Long in Texas to have that's a great test case here. Michael Long, who had no custody right to the child, according to the courts, did not produce the child for months, was not charged with any criminal act at all. The amount of things that had to happen for Michael Long to be charged with a criminal act in Texas for the kidnapping of Sophie Long. Remember, he did not have a court order that allowed him to see her. He had the opposite, a court order that said he couldn't. Still took months. Again, you're talking about committing a felony here. There's no way they get to felonies on this. Jan Campbell MA says Kyle didn't just wound, he executed. As Joe pointed out, a hostility a long time coming. You never shoot to wound. Firing is always deadly force. Why do you say Texas as if it's a foreign country? No, I say Texas as if it's the proper American country. And the rest of the country needs to catch up. Janet Morgan says, could provocation go as far back as the ex-wife misleading him to that property, knowing how he will behave? You would have to show that happened in any capacity. We have no information that she, quote unquote, misled him to the property. I got the intention or the perspective that he was at that property because that's where he would do the pickup. The Real Hydro PX says, I think the stepfathers are the worst things. Every child wants to be with their real father, and no male should stand in the way. Beth Woodfin says, look at Chad's widow's petition for custody of the kids. In a conspiracy theory world, it's sus. Chad was going to go public with Kyle's affair. Dwayne Kate says, remind me what JoJo Rosenbaum died trying. Touching a kid. Don't do it. Everett Merrill says, would interfering in the custody exchange take away Kyle's right to self-defense? No. I mean, not in... Did the question you have to ask is, did Kyle interfere with the custody exchange? And if so, how? How did he interfere with the custody exchange? There was no custody exchange occurring. It's not like the kid was coming out from the mom and Kyle intervened and stepped in front of the kid with the gun and said, you need to go now. You're not getting the kid. None of that happened. Kid's not even there as far as we can tell. Ryan Burkebile says, Biden says we are supposed to fire warning shots. Mirage 337 says, I vote for option 3, jury trial with base judge and uncontaminated jurors. Yeah, that might happen. Again, this is a close question. Understand that when I'm responding to these chats, it's not because I think I'm 100% right. It's because I am 100% right, but I'm posing them as questions that need to be resolved. I've resolved them currently in I lean towards justifiable use of deadly force. I can fully see how people lean away from that. Not actually here to change minds, just open thoughts about it. I don't care if Kyle goes to prison forever or gets a death penalty in Texas. I don't know this guy. Moose and Squirrel says the ex-wife appears to be a judge. Catherine Ruck says the one thing I learned from the movie Chicago is that they both reached for the gun. Danny S says, unlike Rosenbaum, Reed did not lunge for the gun. He didn't lunge for it. Terry Bell says it wasn't a warning shot. Shooter just had shit trigger discipline and fired while struggling before the murder. So maybe that's a negligent discharge. Possible. President-elect Four Doors More Horse says if Chad is picking his son up at the location, he has a right to know where his son is. Napoleon wanted to tie up loose ends for his wife. It's murder. Again, we don't know that he didn't know that. So, but it could be. Real Hydro PX says because you can never use deadly force against a mere trespasser, you cannot use a warning shot. I argue he's not a mere trespasser at that point. OG Boxer says, yeah, he's on property, but under Texas law, can you use deadly force for simple trespassing? Is it a simple trespass? Regular guy says, this crummy as ex-wife set this up. Dragon Poo Poo 94 says, the shooter went into his house, removing himself from any potentially dangerous situation, came back with a gun. I don't know about self-defense. He's still in his house under the statute while he's standing on that porch. Rain 432 says Kyle looks like he deliberately moves inside the arc of the barrel. House of Thrift says it's that guy's place of employment. He says it in the video, I believe. What? Lone Wolf Ranger says premeditated gun too quickly available for home with other guests there. You can have a gun. You can have a gun sitting on a rack on the back side of your front door. That's not premeditation. Shooter never stands by his girl or gets between the two, but stays near the door. Yeah, he's not defending her, I don't think. I don't think there's anything about any idea that Kyle was defending the lady. Really, really big man, Short Bus Dave says, if this is Texas, make my day law, any threat on your property you can shoot. Stephen Pence says, this case similar to a father-son murdered or self-defense in Abilene. You should review the video of the shooting. Johnny and Michael Miller. I'll have to see if we can look at that at some point. Brain says people have forgotten basic survival instincts. Ron Wood says pull again. Haha, I'll use it on you. Turns the tide, I bet. I'm Innocent 07 says sometimes when they touch, the honesty's too much. Really now says that was an accidental discharge, not a warning shot. The5GHAG says you guys are overthinking this. I guess when you're a hammer, everything looks like a nail. Unfortunate, but easily a clean shoot. OG Boxer says I don't know, but Rittenhouse would not have fired, so I'm inclined to still think the shooting was not justified. Killer Combo says, does he get to claim self-defense after being the one to threaten deadly force first? I don't think he threatened deadly force first. I didn't see that. We looked for it. Stephen Sykes says, I believe Chad will be successful in taking them all to court. Gerald Armstrong says, interference in child custody is a felony. As we know from the Arbery case, anything after that is felony murder. That's not actually true about felony murder either. Not anything after that. It has to be directly tied to the felony itself. In this case, if you had the felony interference in child custody, which I don't think you get anywhere near it, you might have a felony murder, maybe. But I don't. You're going to have a hard time convincing me that you're anywhere near a felony of interfering with child custody. Real Hydro PX says his reason for kill Chad was not because he bagged the gun. He said, I asked you guys to leave. That is not a reason. That's not, he said, I asked you guys to leave. This could have been avoided. Never mind. Ariel Israel Ben Zion says, text his way to eliminate husband and boyfriend. Sealy Stars as Twitter reports Kyle is a Lubbock 2A coalition leader. Interesting. CS says, everyone saying that he was shot for wanting his kid and not leaving is leaving out the actual aggressive behavior Chad was performing to intimidate. Agree. Anything for Selena's says, I live in Lubbock. LPD tried to cover this all up. Kyle Carruth has been in trouble before for being reckless and dangerous. His soon-to-be ex-wife is a state judge. Real Hydro PX says there are two major exceptions to the Castle Doctrine. Person seeking to claim protection under the law cannot have provoked or started the incident. And did he start the incident? Did he provoke it? I don't see it. FBI Glow Boy says, I've always understood that if you're holding a firearm, your hands are an extension of the gun. So touching Kyle's hands was provocation. I see he touched the gun before any shots were fired. He moves into nipple rubbing before anything happens at all. Very bad choice. Instructor Mike says, can non-lawyers come on the panel? Instructor Mike, email me. Gerald Armstrong says, look up code 25.03. We ended up doing that. Brain says, the deceased wrestled himself between the shooter and family after grabbing at his rifle after entering lawfully. You think he entered lawfully? He was told to leave. I'm very confused about some of this stuff. Again, to me, the question of whether or not the shoot is justified has to do more with, was it justified at the time he pulled the trigger? I think there are times where he's definitely justified, but whatever you think about that, he did not enter that property lawfully. He remained on that property unlawfully, in my opinion. And once you're told to leave, and certainly if we're going to distinguish between being on the property and then in the habitat under the law, he definitely entered the habitat unlawfully. 100%. The Lone Squid says, I mean, this is my hometown, born and raised in, I'm going to be honest, I think he walks. Care a whole lot about personal property and don't take it lightly. No and no. Says, would being there to pick up the child, which I assume he has some kind of legal backing, change anything? No. That does not matter in a self-defense case. It's not going to matter because he loses any legal right he has to be on the property the moment he's told to leave. David A. Hamilton says, Chad Reed does not believe the child is at the residence. He is only there to argue and provoke. Undead Fred says, is this like Dad Highlander? Can there be only one? Real Hydro PX says, now a child has to deal with his whack mom dating a whack male who killed his father while he was trying to see his son. That's a very true thing. Yes. True and Shabada bad pressure bad calf or bad calf care says, okay, you might be on Team Kyle legally, but are you morally? No. This shouldn't have happened at all. Very tragic. Dan says, apparently Chad Reed owned the house Kyle was at. Have to see more about that. Could change the calculus. Might not, though, because merely owning something doesn't mean you have a legal right to be there. Very, very interesting question. Craig Rowe Jr. says, moved from Minnesota to Texas. The real estate agent explained the Castle Doctrine to us, told us to buy a gun and that people know that everybody is packing. Gonfall says, edit from last super chat, stripped every right from that child from seeing his biological father by killing his child's father. Have a sleep. Andrew Starr says, Teal was aggressor the moment he refused to leave. Jonathan Duger says, can you provoke someone on your property? You can. I mean, it is possible to do, and it can take away your justification. Who is inside the house taking the video? I guess Anne Marie, right? That's who he said. I'm going to bring Anne Marie to court. Ken says, apparently Kyle was not the property owner. However, he lived there. Does that change any of the ways these laws would be interpreted? If you live there, you're going to be, you're pretty much going to be fine. I don't know how to, let's see. So protection of one's own property is a person in lawful possession of land or tangible movable property. So that's going to be, lawful possession if you're there. If you're there. Let's see. The actor's occupied habitation is the definition. It doesn't actually matter who owns it. But even if, like, let's say Chad is the landlord, Kyle is there, it's Kyle's occupied habitation, then Chad wants to enter the property. He can't just do it. He can't just storm his way in. That's still not allowed. Landlords have to give you notice. That is your property. Landlords cannot just come in to your property. So, Jim Fry says, notice how Joe has now memed nipple rubbing aggression, validating Nick's assertion of precedence. Yep. Kimberly Campbell says, but what about the issue with his child? Well, we'll never find out. Chain Breaking Stitch says, you're going to find out that if you're on somebody's property in Texas, they can shoot you, and we like it that way. Voro Kusanagi says, Teal shirt was not threatening originally. Kyle was not justified in threatening deadly force when he got that gun. I don't see the threat. That was provocation. I don't see it. Archangel 978 says, just watch the video. That was murder. If courts do not put this guy away, people will do it for them. Beatrix Kiddo says, but he was legally there to get his son, who was supposed to be there for him to pick up, but he can't enter the habitat. I'm repeating myself. Jill Jide says, this is so nerdy. I love it. It's like arguing over D&D or wargaming rules. Really Now says that wasn't a warning shot, was an accidental discharge. Unlike Kyle, Buddy's finger was on the trigger from the get-go. Angry Bellsprout says, get Nick to listen to Joe Horn 911 call for some real Texan hero energy. Defense of other examples can also do NBPP protest outside his house. Okay, Joe Horn is what I'm supposed to look for, huh? Terry Wuckfit says, according to some reports, the property where the shooting took place belongs to Chad, so it was his own property. Kyle's judge's wife lives in Kyle's house. So then what are they doing? Why, again, that leaves a lot of questions. Why is Chad at that property, or why acting like it's not his? Instructor Mike says it can be alleged that if he did not protect himself and her, if he would have allowed him to grab the gun, it could have been used against him, her, and he would go inside the property. Yep, I agree. Darren Haviland says, so Chad did not have a bat. He did not have a gun. He did not have a rocket launcher, says Binger II. Taylor Cook says, I'm like 20 minutes behind, but the Texas case seems to illustrate why a jury of your peers is so important. A coastal person will view this differently. Eddie Oliver says, Carrott's attorney said all Texans may lawfully brandish firearm to protect themselves, their property, and their business. Again, that's a political statement. That is not necessarily an accurate representation of the law. Because not all Texans, right? If you're a felon, you can't. Juan Mangas Muchas says 942-2A. During the nighttime or criminal mischief at night. This isn't at night, so it doesn't apply. No. That only applies to those specific words. So, okay, where was it? (942-2). Okay, so here's the way this list reads legally. To prevent the other's imminent commission of, all right, arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime. So those two things have the nighttime qualifier. It's because these are lower level offenses that don't involve, arson. Burglary involves an occupied property. Robbery involves violence against a person. Aggravated robbery involves violence with a deadly weapon. So mere theft and criminal mischief are not sufficient on their own unless it's at night. So that's the distinction there. JCaz says, what about reckless endangerment for the people in the house by the window in the line of fire? Maybe. You got a tough one. Real Hydro PX says, if you knew a guy was beating his ex-wife, would you take care of him if you got a chance? No. I'm not going to go vigilante someone for that. Personally. Noah Larson says, did he just call him a mother clucker? I hope so. Speaking of which, the Mother Clucker, a sandwich brought to you by Stanley's Barbecue in Tyler, Texas. Delicious sandwich. Justin Bone says the way in which he handled the firearm might be considered reckless, at least from the perspective of military training. Voro Kusanagi says at the time he got the gun, he had no reason to use deadly force or threaten to use deadly force. That was unjust provocation. Getting a gun in Texas is not provocation or the use of deadly force, especially on your own property. Luke Pearson says, is going inside and bringing out the gun provocation? I say no. Legal Beagle says as much. Lol. Wanted your comment on it. Wait, Legal Eagle actually commented on this? He says that's provocation. It is not. Again, if you have the right to be on that property, it's your gun. You can go out and grab the gun. You can't necessarily point it at someone, but you can absolutely grab a gun. Oh my goodness. Seeking truth and wisdom. Thank you. The Real Hydro PX is the fact that he put 2 in the guy. We know he wanted him dead. You can't read into that personally. One shot might not be enough. Great Lakes Audit says provocation and non-deadly force. Had he not threatened to use the gun on him, getting physical and threatening him with deadly force is a different maker. Caleb Foster says shooter is a land developer here. Wife is a judge. Peter Hill says defense may also be big scary man versus mini man. Being flung like a rag doll makes it self-defense. Maybe. Extreme WX Chaser says bad shoot. John Sorensen says y'all have quite a bit of facts incorrect. I know these two guys and the backstory. I'm not going off the other facts. That's other people are bringing that in. I'm looking at what's on the screen. So what's in the video? Jessica M says, truly appreciate your analysis on these cases. Many legal and civics classes for all of us. Justin Filson says, was a toxicology done on Black Shirt Guy? If he was intoxicated, he is a first bad actor because it is illegal to wield firearm while intoxicated. Michael Henley says, Rekieta is right, and the real root cause of the Kyle versus Chad is a crazy manipulative chick. Juan Correa says to the panel, what is your opinion? The widow, lady in the truck, is now filing for full custody of the children. The John Beck says, didn't you see him touch the other guy's map? Razor 390 says, what role does a court order for child custody shared, allowing the biological father to be on property, habitation, and biological mom for purposes of child exchange could affect the statutes and justification? You have it until someone asks you to leave. Real Hydro PX says it was not a justified killing, maybe by law, but not by common sense. Yeah, those are two different things. Eddie Oliver says, listen, Nikki, I live in Texas. We're not some goofy state like Minnesota. We have property rights and strong self-defense laws. I know. I really hope you tackle the Austin BLM shooting. Google Garrett Foster Austin shooting. I will try to remember that, Eddie. But no, I know. That's what I'm saying. I've said over and over, Texas is not the same as some of these other places. Shinobi Assault says, him saying, I'm glad you're recording this sounds like he's premeditating the murder. Do you often know people to be glad to want to record their murder? I mean, I'm not a murderer, so I don't know. Dino El Ray says, you think Kyle will ever sleep if Chad's 11-year-old son is under the same roof? Who knows? Brandon Freeman says, get Detective Bay to figure it out. CS says, thank you for calling out the family court. Children are not property. Nix Hex says, seems to me once Kyle ran away from Teal, he hadn't exhausted all of their options. But does that matter when property is involved? Texas is a stand your ground state. You do not have a duty to exhaust all other options. The Big Red Snake says, I'm from the Panhandle. I would not find him guilty. Out here, a possible case of entrapment. A strange wife of shooter is a judge. Zaring says, this is a very simple case. Father wants kid. Fathers have no rights. Must end father. Oh, Neo Ritter says, looked into brandishing and within my state's context, but it means provocatively to provocatively show a weapon. This could be just lifting your shirt to show a gun. Texas does not have a brandishing law. that it mentions brandishing anyway. T. Miller says, in order to get to burglary, are we saying that the chest bump is felony assault and not misdemeanor assault? Let's see. What was the burglary statute? No, it's again, there's an important word called or. Enters the habitation or a building or any portion of building not then open to the public with an intent to commit a felony, theft, or an assault. Any assault is burglary, misdemeanor or otherwise. Claire Fry says, the problem I have is that the shooter did not appear to be in fear for his life. He seemed angry and like he wanted to kill the father. Diane Pryor says, Kyle stole his wife through his affair with his ex-wife, now taking away his son. Aish, welcome to paralegal status. Thank you. Scott Baines says, proving consciously beyond a reasonable doubt isn't happening. Taser, taser, taser. Oh shit, I shot him. Shows it wasn't done consciously. Now we're on to Kim Potter super chats. Fuzzy Creature says, I feel bad for this lady regardless of the result. Level of F up here is monumental. Patrick Ells read that one. Catherine Cannell says, look at the Oscar Grant killing 2009 New York, NYE Oakland, the movie Fruityvale. Of course, Michelle charged with murder, convicted involuntary manslaughter. Thomas Bott says, isn't it disingenuous to say that she should have known if they feel the risk is high enough to feel the need to actively train on drawing incorrectly? Josh Wilkes says, thank you, Nick, and the entire panel. Have a great weekend. Groves Russell says, surely why they had a warrant plays a part in this. His warrant is for a gross misdemeanor, so it's not automatically there. But when he runs, he's committing a felony. Economath says Kyle's criminal accomplice to Texas Penal 2503, so arguably was committing criminal act when he shot Reed. Now, I'm still saying, if you think felony interference with child custody is happening because of this video, then might I humbly suggest that you're not aware of how child custody takes place in the United States, all across it. People do that bullshit all the time, and it's not a felony. Ill Machiner says, under felony murder, wouldn't the suspect be responsible for his death? I don't think so. He's not committing a felony. Is this on the GoFundMe? Is that what's going on? Is it on the GoFundMe that he was engaged in felony interference with child custody? Like this talking point is very pervasive. That's why I'm curious where it's coming from. Gerald Armstrong, it's a felony in Texas to intentionally interfere with child custody. Being late, having your child be late for a pickup is not interference with child custody. Like the amount of steps that you have to go into are it's so far beyond that. Chris Ludwig, you said that the father picking up his kid should not have been killed. Me too. The question is not whether it should have happened. It now has happened. The question is whether it's justified. I can, again, if you guys out there think that having a child late for a pickup is interference with child custody, if you think that that is going to meet the definition under the statute, then like 85% of divorced people with custody agreements will have violated that law at some point in time and be felons at that point. No, it's just not, that's not real. Like that's why I'm trying to find out where this comes from. Other than just like, if people are reading it in the law and coming to that conclusion, let me fix you. Maybe I'll do research on it specifically with the case law from Westlaw to do that. Not on this show, because we're already coming up on 4 hours and these are supposed to be 2 to 3. But yeah, just from a reasonableness standpoint, there's no way. Oh, it's from 4chan? Okay. Yeah. I will humbly submit that that is not an accurate read of the law. Okay, next. The anime guy says, blame police defunding anti-cop stuff, cop walkouts, and leadership for forcing a paper pusher who's a rookie to the field because lack of staff. Mean Sarton says, big lesson from Daunte Wright and Jacob Blake. Take your arrests like a man. Everybody takes an arrest from time to time. VT Wayfaring Man says, LEO use of deadly force has to be intentional, even if justified. Shouting Taser and her reaction after shows not intentional negligent discharge. I've never seen that case law, but maybe it's true. It's not in the statute. A random custodian says, I just watched the video on the Chad Reed shooting, and that looks justified to me. Man told him to leave, and he didn't. Chad should have had the cops there. Instead, grabbed the gun and threw him. Again, tough case. Don't misunderstand me saying that Chad Reed is an easy case. I just think it's justified at this point. Other facts could come to light that change my mind. Woodman Gaming says, speaking of reckless use of firearms, would you like to go to the gun range with me? Hell yeah, man. Just laugh and honk your nose says, Nick, I'm going to host a daytime stream that's more YouTube friendly. Also, Nick, let's watch people get shot. Brandon Lesko says, can we please assault the whiskey? No, I can't. I got to go do stuff. I got to drive, man. CC1138 says, you planning to cover the trial of Darius Sessoms, guy who shot a white boy dead just for stepping on his lawn in 2020? Read that it's in December. Maybe. Depends when it is. I'll have to look that up. If you could email me that, I'll take a look at it. Jay says, can confirm with Nick, didn't see my son for a year when his mother took him and disappeared to a different state. Couldn't get kidnapping charges on her and was told to go back to family court. It's just how it works out. Is it right? No, it's not right, but it is. Call me Straw says, see you tonight then, Boomer. By the way, did you get my email? I never got a confirmation, so I just need to know if I need to send it one more time. I think I did. Jar of Austin says, when it comes to the Reed Kyle, I'm wondering if the guy, through his rage, had any training to know to get close range because it's a long gun. Maybe. AGK says, fun thought experiment. Would you be more likely to cause a gun owner to be convicted if you broke into their house but always faced the front door? So like, oh, so you're always leaving. So you're always, maybe. I guess. Patient Zero says, law dog in the internet. Bishop Craig says, can you push a weapon away as self-defense? Maybe, but it's not the state of mind of the guy pushing away. It's the state of mind of the guy pulling the trigger. Oh my. Oh my. Bogey34 says, you should post the poll results on Twitter and track it as a baseline for the Potter case. Same poll each day of trial with total sample. Colin Stiernagle says, never fall for the siren song of a chicken beckoning for violence. Crash Mondo says, I think up until he was flung off the porch, Kyle was entirely justified to cap Chad. Can't get past the pause, no matter how fast he had when he aimed the kill shots. Zach says, poll option, Minnesota jury convict any cop no matter what. If you are a cop in Minnesota or other communist hellholes, you're asking to go to prison. Polaris 589. How do you feel about paralegals and how should I go about becoming one without getting a certificate/degree? I have no idea on the second question. Paralegals are invaluable to keep you on schedule, to make sure you're complying with rules. They're great. It allows you to focus on the case. How do you become one without getting a certificate/degree? I don't know if you even can personally. I think you got to get that certificate. Squawk 7500 says, during the Rittenhouse case, there was a lot of mention of directed verdict and JNOV. You know, any examples of cases where those have been used and how do they compare to the Rittenhouse case? I mean, off the top of my head, no, I could research and find them. Steve C says, people still arguing structure or habitat. What about curtilage? Is that not part of the dwelling? Look, the habitat is the definition that's used in the statute. That's why or habitation. That's why we're talking about it, right? Habitation. Enters a habitation. This is a burglary statute, but habitation means these things. And then the justification is not for protecting property. That's up here, but under just general self-defense of person is when they occupied habitation. Unlawfully and with force entered or was attempting to enter unlawfully and with force. The actors occupied habitation. Again, telling someone they cannot remain on the property means they are no longer lawfully on the property. Once he goes from the yard onto the step or onto that porch, he has entered the habitation unlawfully. The question is it with force? I'm not sure what that means. I got to look at it. Gigoku says, sorry about my chat message last night. I did not have all the information about the anime Matsuri situation. Oh, you're fine, man. You can have an opinion that disagrees with me, but I will, if I see it, I'll talk, I'll address it. Doesn't make me mad. Stonehorn says, what's your favorite 40K faction and why is it orcs? It's not, it's custodians because I think they're hilarious. Tim Smith says, was the child even present when this went down? Thanks for all the great info. I don't know. Appears no. Porches are not open to the public once you have told someone that they cannot be there. I keep seeing porches open to the public, but they're not. They're not open to the public once someone tells you to get off the property, and they are part of the habitation under the statute. So ringing a doorbell is unlawfully entering a habitat. If you've been told to stay off the property by someone and they have a gun and says, leave my property, then yes. Yes, if you then try to ring their doorbell, you are unlawfully entering the habitat under the statute. Okay, so Tech Priest Alex says, this shooting just shows that men should continue to go their own way even more. Chad was laying there and no one batted an eye for him. Sealy Star says, real question as to whether LEO should even carry a taser, as they can be lethal force, just confuses the officers, but lefties want them. Yeah, I don't know whether they should or not. Killington says, an objection of lawyers. Redacted says, should have a legal language dictionary for these people that can't wrap their brains around legal definitions. Isaac Portillo, thank you for the donation. Peter Watkins says, don't feel bad for me. She effed up bad and I'm going to destroy her in court. I'm going for full custody and she will likely end up in jail. Well, it sounds like that's the just result. So go do it. Jordan C says, you can see in the video, Chad fights for the gun and pull both people off the porch. Camera moves and the shots fire and Chad ends up on the porch with feet hanging off. Chad could have moved back to the habitation. Again, let's go back to this. If you unlawfully and with force remove, or was attempting to remove unlawfully and with force, the actor from the actor's habitation, this 1,000,000,000% happened. At this point, when you unlawfully with force remove someone from their habitation, we go back to here to this part, right? This thing. If this exists, then this happened for sure. It's like that did happen. The question is, did provocation occur to mitigate that and all that stuff? Let's see. Jenny's getting inky with it. Says, could the Blue Shirts family sue the one recording for not stopping and calling 911? I think the one recording was the Blue Shirts family. No, they cannot do. They wouldn't be able to sue there, but they could sue Kyle. They could sue Kyle for wrongful death. Thought Provoking says, I think they should all be tried for criminal indifference for the way they ignore the dying guy and continue arguing. That was crazy to me. 200 Watt Studio says, aggressive rubbing nipples is called bingering. FF says, should I think about law school? I have physics BA, but feel bored of my job. Is it worth getting a JD with a STEM degree? Yeah, you can become a patent attorney and do really well with that. But that only if you want to do legal work. I mean, if you want to do legal work, go do it. And you have physics, a hard science underlying bachelor's. That means you could pass the patent bar. You could be a patent attorney. I can't. And patent lawyers can do some really cool stuff and make a lot of money. But only do that if you want to go to law school and become a lawyer. If you want to do something else, like just a nebulous something else, don't do that. That's Danzatastic says, didn't Chad have a gun at the beginning of the video? It was a little blurry, but it looked like he had a gun in his hand. If so, he came to the property with fun. I don't think so. William Haydock says, I've been living in a cave. What's going on exactly? Storm D says, this is why a stoic attitude is crucial. Rare occasion. He had the courts on his side. Should have waited for the cops off his property. WOX42A. And that's one thing to consider here with Chad. It's shit that she's keeping the son from him if that's what's happening. Do you want to lose your life or even ignore the fatality of the incident? Let's say there's no gun involved. But the guy says, get off my property. Get off my property. And he doesn't do it. They call the cops. The guy ends up going to jail for criminal trespass rather than seeing his son. Was that particular time he's seeing his son worth the potential consequences that he was facing? And maybe the answer is yes. I don't know. But you have to consider that too. WOX42A, thanks for donation. Damian Jackson says, can I get an overview of the situation, please? I'm not going to revisit the whole thing. Christopher Shaver says, if Chad has a legal right to be there to pick up his kid, how could he be trespassing even after a warning? That's my issue. Because it doesn't matter if you're legally on property. If someone asks you to leave, you have to leave. It's if a person lawfully in possession and occupation of the property asks you to leave, they have to have the authority to alienate you from the property, then they do. You can't just stand there just because you have a court order that says you can come pick up your kid. That would be, again, because think of the extension of that. Well, I have a court order that says I can pick up my kid. I can go in and just go in the house and sit around, take a shower or whatever, poop in their toilet. It doesn't work that way. Jonathan Duger says, how do we know that Chad wasn't the POS who liked to hurt kids? I have no idea anything about these parties. Trying to keep that out of it. Dragon Warrior says, it is a hard sell to prove mens rea on the part of the shooting, but family law is ugly, and I hate these kinds of cases. Prima facie, it was justifiable. Claire Fry says, moral of these stories, most preventable deaths can be laid at the feet of a woman. Jillian Seed says, divorce is degenerate. CS says, my cousin's ex broke into her home at night and was caught by her, claimed he only wanted to see their infant son. I know someone that this happened to. Also, we might know the same person. I know the person who, quote unquote, broke into the home, entered the home without permission, for that same purpose. So These Nuts says, Julia Cruz case out of Missouri. Have you seen it? Cops pulls gun and not taser. I have not seen it. Uriah Wright says, Kim Potter is the reason why we need to repeal the 19th Amendment. Really Now says, Kyle was assaulted. He created distance and directed the shot away from any follow-up targets. I still think it was a bad shoot, but justified. Mandy Carvicka says, your shirt reminds me of an uncooked turkey, Nick. It's fair. Really Now says, just because you are not scared or show remorse does not mean you didn't have fear for your life. The moment Chad moved the gun, if I was Kyle, gone. Tech Priest Alex says, doesn't really surprise me. People praising this shooting. Horseshoe theory is real. Both political wings are the same. I don't know if people are praising it by saying it's justified, but I'm not. I don't want anybody shot. Certainly not over a custody dispute. That's ridiculous. But I think it's justified right now. Rob says this loss of life preventable. I'm pro 2A, but from watching it seemed he enjoyed it. I agree with your summation of the law. Maverick X says, I always thought rubbing nipples was a sign of being friendly. The Helmet Head says, hey, Nick, talking with my family and friends in Lubbock, more find it unjustified than do. Apparently, if charges are brought, the case will be tried in Amarillo because most people have an opinion. Ill Machiner says, I was talking Kim Potter. Oh, sorry, Ill Machiner. Tom says, how much time do you have to leave property? A reasonable amount. But remember, you can't just shoot somebody for remaining, right? Like that's a criminal trespass. A mere trespass is not sufficient for deadly force. He wasn't engaged in a mere trespass. He, under the statute, assaulted Kyle by going in and bumping into him, and then certainly by grabbing the gun. Economath says, swap the genders. Gallegos versus State. Okay, I'll have to see if I can find that. It's on Lexus, huh? I don't have Lexus. I use Westlaw. I don't know if it's there, but I'll check it out. Not Heisenberg says, tasers are great for subduing a suspect that would otherwise require nightsticks or other heavy physical force. Boro Kusanagi says, if you can't use deadly force to defend property, then why is he justified to get you can use deadly force to defend property in Texas. You can. Why is he justified to get a deadly weapon to threaten someone off the property? Chad wasn't approaching the habitation at that point. No, in Texas, you can use deadly force to defend property, and you don't have to have justification to merely get a weapon and hold it. Threatening while holding a weapon does not amount to... Actually, he doesn't threaten him. That's the thing. It's not a criminal threat. Pastor Flash says, Sonny Hollow was great last night. Stayed and listened much longer than expected. She has a magical voice singing one of the Lord of the Rings songs. Great one. I've seen Fire, whatever. Fantastic. Bird Bath Bash says, seemed as though no one gave an F about Chad. Maybe a setup knowing his nature would lead to this outcome. Radio Ruin. I'm not going to delve into that. I'm just going off what evidence we have so far. Radio Ruin says, if Chad got his hands on the weapon and got Kyle instead, how screwed would he be? Very, very screwed. Isaac Bowles says, I just watched a stream from Destiny and another one from David Pac-Man. I'm pretty sure I have AIDS now. CS says, did the guy you know also tear his Achilles crashing into her AC unit on the way out of his ex's house? No. We joked she needed a perimeter of more AC units. No. That's not what happened. So that would have been funny, though. Red Guy says, one of my friends told me his hot take of the Wisconsin thing. He said they partially deserved it for having a Christmas parade before Thanksgiving. That's a take. That's a take. All right, guys. There you go. That's my read of it. We'll be talking about it more as more details come to light. I think it's very interesting. Obviously, a close case because people cannot, it's split. It's like evenly split. So, reminders. There will be a stream tonight. Not quite sure what the subject will be yet, but we'll talk about something or maybe have a guest. Tomorrow, Monday, Nathan DeBruin, 1 p.m. Central Time. Photo Chad from the Kyle Rittenhouse case would like to do an interview. So we're going to do an interview. I think that'll be super awesome. And then Tuesday, 1 p.m. or Tuesday morning, probably 9 a.m. Central Time. The trial of Kim Potter starts. I don't think it's going to be anywhere near as long as Kyle Rittenhouse trial, but we'll see. We'll see. All right, guys. Oh yeah, Drex probably tonight. And if you've never met Drexel, you're in for a treat. You're in for a treat. So yeah, I think, assuming he actually gets here, he said he's coming out today to come hang out around Thanksgiving time. So assuming he makes it here and something doesn't come up, then that's that. All right, guys, catch you soon. Peace. Peace.
Your Honor, I'm pretty sure we have a mistrial here, sir.
I'm gonna mistrial my foot up your ass. You don't shut up.